Hello, morning. Could you identify yourself? Emerson. Where's Johnny Bell? See if you can get him on the phone. Yeah.
I think he had a hearing with Judge Christie this morning also. I don't know if he's here yet or not. I don't know. I actually saw it.
Well, let's try to get him on the phone. You go back, take your seat there. City lawyer gets here. I apologize for pointing at you folks. I know it's rude, so I'm not being disrespectful when I do that. That's about the way we got to operate. Christopher Davis. Office of Public Advocacy.
I apologize. I had a little bit of trouble trying to hear him.
No, don't pull your mask down. Leave it up and just speak louder, okay? What's your name? Christopher Davis. Yeah. The plea? Yeah, okay. Commonwealth of Kentucky versus Christopher Brian Braden Davis, 21 CR 0083. Are you Christopher Davis?
Yes.
What's your year of birth?
96,
Last four digits of your social security number. We were here today on a pre-trial conference. What do you have, Mr. Stockton?
We prepared paperwork on the pre-trial verdict. It's 3 years.
Your attorney has COVID. So he's not here. So this attorney here is substitute. It's just gonna take a while. Don't worry about it.
It does appear that there is some completed paperwork on the offer.
Okay, a motion has been filed that says that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? Are you the same person named in indictment number 21 CR 0083?
Yes.
Have you had plenty of time to discuss this matter with your attorney and have you reviewed all the evidence? Are you satisfied with her advice?
Yes, sir.
Yeah. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you, okay, y'all need to step away from there and talk. I'm gonna give you enough time to talk. You need to step away and talk for a second. Well, I mean, you can if you want to.
I was just trying to get the file on my paperwork.
Well, just step away and talk to him if you got, we're not gonna rush him through. I'm gonna make sure he has enough time to talk to you. You need to move away from the microphone if you're gonna talk to him. We're picking it up. I'm good too, but I just don't want you to say anything that would pick up. You got.
I'm not really sure what happened here, but his dial in it was showing active.
Evidently not.
I mean, I see a bond decision filed and, I mean, arraignment orders and everything, but somehow he's managed to never get served.
Was he rained?
Yes.
That'll be all right.
Withdraw the warrant.
Withdraw the warrant. Is there no other reason for a warrant to be added, I guess?
Do you hear that, Jamie? Withdraw, I need to withdraw the warrant. Yeah, I do have all the signed paper.
Okay, I'll go through my process here. I just will make sure. You have a right, you have certain rights under the Kentucky and United States Constitution. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel at your jury trial, the right to confront, cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter at higher court if you lose, and the right to require the Commonwealth prove on a reasonable doubt that you're guilty of the charges against you. You understand that by entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendations, or I may provide, or I may reject them and try to sentence you to something more stringent than that prior to accepting the recommendation. But this is a pretrial diversion here. And what that means is if you successfully complete the terms of a pretrial diversion, your case will be dismissed, pretrial diverted, and you can get it expunged. You will not be a convicted felon. However, if you violate the terms of pretrial diversion, they bring you in front of me and I enter an order finding that you have. I'll order a pre-sentence investigation report to be done by probation and parole, and you'll be a convicted felon. And if you had any felonies in the future, then they could be enhanced because of that. You understand that? You step to the left there, and Mr. Stockton's step to your left. Both of you step to the left. So you step to your left, man. Okay. Okay. So Mr. Stockton, go ahead, Mr. Stockton.
Your Honor, Mr. Davis will plead guilty to possession of controlled substance, first degree, receive a sentence of 3 years, pretrial diversion for 5 years. He'll pay a fine of $500 on no insurance, receive credit for time served, remain on active supervision while all fines and court costs are paid. Obtain and maintain gainful employment and all evidence in this case will be destroyed.
Okay. What is the court cost in this case? You can come back over here now. $230 plus a $500 fine. So it'll be $730. You need some time to pay that.
Yes.
Okay, I'll let you pay it $75 a month, starting 30 days from today. Okay. And that's the agreement you reached that Mr. Stockton just went over. Is that correct?
Yes.
Okay. So I'll need you to meet with a probation and parole officer over here. Is that your signature on the document? Now you can show him the document. Okay, we'll take it, file it here. If you want to. Madam Clerk, there you go. Okay, over there and meet with the probation parole officer. Come on in here. Good morning. Thank y'all for coming in. Okay, I'd like for you to raise your right hand. We solemnly swear or affirm that you will do your duties as a member of the grand jury of the Monroe Circuit Court. That you keep all things confidential that you hear down there, that you will protect and defend the Constitution of the Commonwealth of Kentucky, United States of America. So help you God. Thank you. I'll need to go with the Assistant Commonwealth Attorney there. Thank you for coming in. Okay, let's start back over here again. Mr. Bell appears to have joined us here. Morning, Mr. Bell. Sir, you want to come up here and identify yourself again? Mr. Emberton, right? Commonwealth versus Ricky Lee Emberton, 20 CR 0087. Mr. Emberton, were you born in 1963?
Yes.
Last four digits, social security number is 0973?
Yes.
Okay. We're down on pretrial conference. What do you have, Mr. Bell?
Your Honor, I believe that we have discussed this and we're just going to have to get a trial back on Mr. Henry.
I agree with Mr. Bailey. I would suggest, Your Honor, it was set after the first of the year, set with the backup, bail case on November 15th.
Okay, what is the case on November 15th?
That's, the guy we were in the trade with, the sheriff.
I don't believe that one's, I think it'll go with.
Let's set that first.
Sure, some kind of national disaster that we cannot participate. You can't. I don't have these relays. What do we have on the 18th?
Of January,
Yeah,
but we have an IRS.
got new event there. Yeah. I think we ought to just sell. Mr. Bell is so concise, Mr. Stockton, we could probably do his in one day. Okay. Hmm. 18th and 19th.
That's good with me, Your Honor.
Okay, January 18th and 19th. You'll continue in the same body. Is there a need to schedule another pretrial?
I don't see.
Okay, we'll see you on the 18th. Be here at 8:30. Thank you. Yeah. Okay, sir, you want front row there? Stephen Reed. Okay, let me get him in front of me here. I've got Commonwealth of Kentucky versus Stephen W. Reed, 19 CR 0070. Are you Stephen W. Reed?
Yes, sir.
What year were you born?
1983,
Last four digits of your social security number.
2907.
Okay, what date do you want on this, Mr. Stockton? Mr.
Mr. Bell said he was on vacation, and he said he would come and see me.
I'll wrap his office, Your Honor.
The next motion. He said he will, the first time.
So y'all are gonna arrange a negotiation date, and then this gentleman will come back here on October 21st. Is that correct? Okay.
We can get it resolved.
As a part of your bond agreement, you'll need to comply with your attorney on what day the negotiation day. You'll have to be available and come there that and then be here on October 21st. Okay,
Yes, sir.
thank you very much. So let's go in the second row, young lady here on the end. Yeah. What is your name? Amanda Short. Who's your attorney? Did you go through district court? Did you go through district court? Had Department of Public Advocacy, yeah. Have you had an opportunity to speak to this lady, counselor? Have you spoken to this person?
I have not, Your Honor, I apologize.
Well, I mean, you no reason to apologize. You just got thrown in the middle of the whirlwind here. What's the story here, Mr. Stockton?
5 years. And it's on 2 possessions. And she was granted diversion. And she received a DUI. So that was Monroe County, 21P279. I don't know if that moves off. Still pending. Okay. And that's the story. So I filed this. Typically, what I've been doing is people get the DUIs on probation is either sending them, let them get sent for drug court or asking the court to revoke.
Well, what are we gonna be like with a regular attorney? When will he be back? Maybe next month or what?
I'm sorry, Your Honor, can you say that again?
The regular attorney that is handling her case, who was assigned to her case?
That would be Robert Austin.
Was he already here when she
I
entered?
think this motion wasn't filed until the 30th day of August. So that was probably, yeah, a couple weeks ago.
I didn't know whether her initial plea, what I'm saying is predates Mr. Austin's.
It predates, it's 18 days. It predates.
Yeah, so I mean, he doesn't know anything about it either, is what I'm saying.
If you want to set it on October the 1st, but she needs to be closely supervised with Mr. Collins. She's been sick. Well, that's the problem. They're always reputation. Where do you live? Innocent. I couldn't put a drug court.
Where is the DUI charge at?
The DUI is here in Monroe County. That's one of the reasons I wondered if she was living here. She's up here, it looks like, without permission.
She has an active probation violation warrant.
Yeah, I guess it's been served.
On the 31st.
Okay.
30th.
What do you know about this?
Your Honor, she received a DUI back on 8/27 here in Monroe County. I spoke to you about it. I know all the DUI cases will be issue probation violation warrant. I notified Tennessee, and they never got back to me, so they told her to come up here. So that's a good thing. And she showed up. I sent her a letter. I guess not. Well, the way they notified me through our ICOT system. DUI, we had to address that.
Was it an alcohol charge or a drug charge?
She did consent, so we're probably not eliminating that yet. Like the citations.
I talked to her a little bit this morning, Your Honor, and she did say she slipped up, but we didn't have a chance to.
Was, I've got a warrant out for her. Okay. It is a DUI. She does live in Tennessee. It's not a good, are you working anywhere? Are you disabled? Why aren't you working?
I've been on with my children, my son's virtual.
When's the last time you had public employment? When is the last time you had a job?
In Louisville.
Yeah.
I've done unemployment consideration.
It was pretty lucrative. Is more money than working, wasn't it? Yeah, you joined the rest of America, but not working for a year and a half. So they never said people were stupid. You know, I mean, if you make more money staying home, most people will, you know. Yeah, well, you could have been, what do you want to do, Mr. Stockman?
Gordy, not.
It is a Gordian knot, yeah.
I'd either ask them to go to jail or be placed on home incarceration. This case.
Can we put someone that lives in Hermitage Springs on in-home incarceration?
Yes,
How much will that cost her to set up?
145 today.
You pay $145 and how much, 95 a week. Can you do that? Personally, I don't.
I like.
I know.
Yes.
No. Okay. I guess,
I would like to have
okay, you're gonna go into custody right now. They're gonna serve the warrant on you. But I will allow you to be released on a ankle monitor. You're to stay at home. I want you to sign a waiver of extradition here. You got one of those waiver of extradition forms, which means that you will not fight us bringing you back to Kentucky if we have to send the police. And you did come here today, that's a good sign. Well, I don't know whether that was a good sign for her or not. We'll see. You'll fill that out for her there. And, will you have to transport her to Barron County before she does, or will you have time to, while she's here? Okay, so what we'll do, rather than transport you to the Barron County Jail, they'll allow you to set up what you need so you can get set up on the ankle bracelet, ankle monitor. Now, you need to be extremely careful from here on out. I'm also going to do a drug court referral on you to be assessed for drug court. You probably live close enough to the line that you could live in Monroe County if you really wanted to, right? Do what?
Yeah, I live that close.
Yeah, okay, so we'll take a look at both those, but as my old, well, my old law partner used to say that people need to live at the foot of the cross, and you need to live at the foot of the cross right now. You don't need to get into anything else, I promise you. Okay, let's go next here. Okay, here you go. Let's go in the second row on the aisle there. You want to come up? Miller?
Yes, sir.
Commonwealth versus Adam A. Miller, 21 CR 0002. Are you Adam A. Miller?
Yes, sir.
Born in 2000. Last four digits, your social security number 7308. What do you got here?
No, we were able to negotiate what I was recommending, Mr. Miller, yesterday. I would ask the court give us to the 21st, get all that right, and let me have a chance to think.
We got plenty of time.
If he wants to take it.
I'd like to go back on 21st, but.
Well, yeah, but look, we got so many cases. If we've got a resolution, this thing, we need to get it notified. I want you to send a trial.
I understand that.
There's some, do you want to meet him now? If we come to one of your other cases, we'll pass over your case and come back, okay?
All right.
Take him one of those conference rooms back there again. Okay, young lady over here to the right. That'd be you. Well, I didn't see, I couldn't tell which row you're on, sir. I'm sorry. It's okay. Come on up. What's your name?
Sarah,
Commonwealth versus Tara K. Thomas, 21 CR 0091. You are Tara K. Thomas, born in 1991. Is that correct?
yes, sir.
Okay, why don't you move up just a little closer to the microphone? And last four digits, 2808 of your social security, correct? Okay. We're here today for pretrial conference. What do you have, Mr. John?
Bates and I have spoken on this phone, but we didn't meet during the last negotiation day, because I was like, he couldn't be here on October the 1st.
October the 1st at 9 a.m. for negotiation, and your next court appearance is October the 21st, okay? And both of those are conditions of your bond, so you'll need to keep in contact with your counsel. Be here October 1st at 9 a.m. for negotiation, and your next court date's October the 21st, okay? Thank you so much.
Thank you.
Yeah. Sir, would you like to come in? State your name, please.
Robert Spurlock. 479.
Wait just a second. Robert Scott Spurlin, 20 CR 0054 and 79, last four digits, social security number 2722. Okay, who's your Office of Public Advocacy? Is that correct? This is an arraignment. Were you in district court?
I was, they released them on the council.
Yeah, but who is your attorney there?
They have it.
Okay, you want to come around, then I'll continue the point. We're here today for the purpose of arraignment. You have the right to remain silent. This lawyer here is with the Office of Public Advocacy. The grand jury of Monroe County has returned an indictment charging you with possession of a controlled substance in the first degree, possession of drug paraphernalia, and public intoxication. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
What's the negotiation day?
October 1st.
Okay, October the 1st, you be here with your attorney, and the next court appearance is October the 21st. Both of those are a condition of your bond. Both of those days are, and I'm going to sign a reciprocal discovery order here in a minute. And they're going to be giving you the information so you can prepare the defense of Mr. Spurgeon.
Your Honor, is this our copy of the indictment?
Yes.
Okay.
That's your discovery that they gave you.
We'll acknowledge receipt of the discovery.
Okay. October 1st and the 21st. Okay, thank you.
Thank you, sir.
Yeah. Young lady, you want to come up next? What's your name? What? Brinkman? Roten. Commonwealth of Kentucky versus Christina Roten, 20 CR 0079. Ms. Roten, were you born in 1986? What are the last four digits of your social security number? 8192. Okay. What do we have here, Mr. Stockton?
I have a proposed plea on the pretrial version.
A motion has been tendered that says you wish to enter a guilty plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 20 CR 0079? Is your judgment affected today in any way? Have you had plenty of time to discuss this matter with your attorney, and you feel like you're fully informed about the case? You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one makes sense. I've got to take this call. I'll turn it off right now. Back doors. I'll turn the system off. Don't do it. Yeah. Okay. Okay, excuse me. Have you reviewed the evidence the Commonwealth has against you? Do you feel like you're fully informed about your case? I haven't read you your rights yet. Was I going down through those when I stopped? You have certain rights under the Kentucky United States Constitution. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial, right to be represented by counsel, the right to confront and cross-examine all witnesses, the right to produce evidence, the right to call witnesses in your favor and have process issued to compel their attendance, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove on a reasonable doubt that you are guilty. You understand that? Okay, is this a diversion, did you say? Okay, by entering into this diversion agreement, you agree to comply with the terms of the pretrial diversion. If you violate the terms of pretrial diversion, they bring you back in front of me and I revoke it. Then I'll have a pre-sentence investigation done by probation and parole, and you'll be sentenced. You'll be a convicted felon then, and any felonies that you have in the future could be enhanced because of this plea. Do you understand that? Are you pleading guilty because you are guilty and for no other reasons? Okay, if you'll step to your left a few feet, and Mr. Judd is going to read what the agreement is. Listen very carefully, okay?
Upon plea of guilty for possession of controlled substance first degree, the defendant shall receive a sentence of 3 years pre-trial diverted to 5 years supervised. The defendant shall receive credit for time served and pay a $500 fine. The defendant shall be referred to the Social Service Commission and follow any and all recommendations of the commission. The defendant shall pay a fine and court costs at the discretion of the court. The defendant shall remain on active supervision until all restitution, if applicable, fines and court costs are paid in full and further on support. The defendant shall obtain gainful employment or do a minimum of 30 hours per week community service for gainful employment training. The defendant agrees to have any and all contraband, drug paraphernalia disposed of in accordance with the laws of Commonwealth protecting and holding it.
Thank you, Mr. Judd. Is that what, come back, is that what you agreed to, young lady? Okay, are you pleading guilty because you are guilty?
Yeah.
Okay, are you satisfied with the advice of your attorney? Okay, will you look and identify, is that your signature on the document? Okay. Counselor, if you approach here and, yes. Okay, well, I'll accept the terms of pretrial diversion. You need to meet with the probation and parole officer over here. Was there a drug court or anything in this?
No, that was originally defined.
Pardon?
That's originally defined. She didn't go into it.
You don't want to try a drug court?
He wants to do it, but I wasn't fine.
How much was the fine? Would you like to try drug court instead of the $500 fine, or? Well, it doesn't matter to me either. Okay, well, drug court is a program where you meet weekly and you have to meet certain requirements. They can do random drug tests on you. You'll have to have a job. You have to report on time. It's a structured sort of thing to help people that have problems with drugs. And if you finish drug court, you'll be diverted, pretrial diverted. You're already diverted, but you can have your record expunged after a while. Now, if you don't want to try drug court, you can pay the $500 fine and avoid that. So if you think, do what? Yeah.
Is there any difference with the game in Tennessee?
That's the reason. Okay, well, you just pay the fine. We wouldn't want to teach anybody from Tennessee anything here. You wouldn't want. Because y'all don't have COVID down there. You notice they tell me go right along the line. There's no COVID in Tennessee. Oh, is that right? That's what we heard. Okay, well, you need to meet with, you need some time to pay the fine. What are the court costs?
$265.
So we'd be $765 total. And I'll let you need some time. I'll let you pay it $75 a month. And the first payment's due 30 days from today. Okay. Now, do we need her to sign a waiver of extradition if she's a Tennessee resident? Probably.
Probably an idea.
You have, where's the forms
I
at?
said to Mr. Collins.
You have a waiver of extradition?
I'm sorry.
I've given him my last one.
We're running a little low on those wave bricks. Too. We've had a box office bid. Okay, go over and talk to the probation parole officer then, okay? Thank you. Okay, young man over here in the blue. We got others waiting outside, or is it? What's your name, young man? Temple? Okay. Commonwealth versus Mason J. Temple, 20 CR 0009. You are Mason J. Temple, born in 1999. Last four digits, social security number are. Okay, you're here today. You have a plea in this case. Is there a plea?
Your Honor, there's not a plea today. I do apologize. I'm speaking for his regular attorney. He's not able to be here today. I did have an opportunity to speak to Stockton last night. And I made the offer, however, the principals requested some additional time to consider that offer. What typically likes all of that worked out at prior dates, and I do apologize that.
Quit apologizing to me.
No, it's not necessary. I think Mr. Austin and I were back and forth on negotiations when he got sick, so I don't mind if you want to set this October the first.
October 1st,
Yeah, on the 14th.
October the 1st, and then the next court date is October the 21st, and you're under the same bond conditions, okay? And make sure she's going to give you the contact information. If we don't, on the 21st, if we don't have an agreement, we'll set it for trial. Okay, thank you. Okay, let's go with you, sir. What's your name, sir? Pardon? Keith Gross. What'd you say? What page is that? Okay. Yeah, 30. Commonwealth of Kentucky versus Keith Gross, 19 CR 0053 and 18 CR 00160 and 20 CR 0024 and 21 CR 00061. I understand that you wish to enter a plea today. Is that correct?
Mr. President advised me that he was not interested in a plea this morning, Your Honor.
Okay.
Well, no one's helping, right? They're supposed to have a bond. They went to a bond and now they're on top for it. They're supposed to, I'm waiting, so I guess we're waiting.
What is this, a pretrial diversion or a felony plea?
Probation. 5-year probation. And some requirements on that.
Okay. Okay, we'll just set it for trial then.
Which case do they want to call?
Your Honor, I do not have Mr. Austin's trial schedule.
Well, I'll set it far enough out to be all right.
Understood. Thank
It'll
you.
be in January. Okay. Yeah, there won't be any plea agreements now. You understand that? Okay. What about January the 26th and 27th?
The 27th, Judge, will be general motion.
Okay. Well, we've got a case set. I've got Commonwealth versus Powell in Cumberland County on the 24th and 25th. Is that what y'all have? How about the 31st and the 1st? Do what?
Case going to grand jury, say, court may want to be on, and then, I'd like to elect on one of the cases. I could even die. May try to one to ban that.
Yeah. The 31st. You want to just have him back here for the next rule day? Rather than set a trial date? We'll set a trial date. October the 21st, and there's no reason to have a negotiating. What?
I'm just checking, make sure it's today. You may not think that.
Well, let's set the trial here for February 1st and 2nd. Yes. I'm on the bench. What's going on? Yeah. No, go ahead. Hold on just a second. I'll step off the bench. Second, hold on. First and second. Okay, you'll be here on February 1st and 2nd for your trial, okay? Take a short break here.
Final pre-trial conference for that.
It won't be pre-trial conferences for him. He needs to turn down the negotiation to be a trial.
Very strong.
That's a difference. See, like, in the case in this one. Third.
Well, I'm proud of help.
I saw this. No, how you think this is.
Unless after they got stripped down, down the three. Whenever I was.
That's the same thing.
Courthouse, the selection of construction manager. All the reasons why we take clocks. I guess I'll have to go over there. I don't know, but I've got the evaluation. Okay. Okay, sir, you want to come up? Did we do gross? What's your name, sir? Ricky Hammer. Ricky Hammer. You a lawyer? Public advocacy, yeah. Commonwealth versus Ricky P. Hammer, 21 CR 0059. Are you Ricky P. Hammer?
Yes, sir.
What are the last four digits of your social security number
8588.
and your year of birth? Your year of birth? When were you born?
1685.
Okay, you're here today on a pretrial conference. What do you got?
Your Honor, I'm saying it was here for sentencing. It's here I have.
Last month I come back for a child diversion, but I was done on probation, so I put there for child diversion. But in the paper that they didn't get today for child diversion. I'm there with child support.
I understand. I got it right here, but I just gonna see what we're gonna do.
The offer we did, where he entered the plea was probated sentence. So if that PSI says pre-trial version, it should be correct.
Where is the, we don't have a copy of the pre-sentence investigation. Well, I don't have the pre-sentence.
Paige, do you have a PSI on him?
PR Ricky P. Hammer, you're here today for sentencing. Have you had an opportunity to look at this pre-sentence investigation report? Do what?
It's just a copy.
Have you looked at that?
Yeah.
Is everything in it correct?
Outside for child diversion.
Well, I don't understand why the pretrial diversion is in there because we wouldn't have a pre-sentence investigation report if we were pretrial diverting. I know, but I'm just talking about on the face of it.
I know, it's because whenever I talked to Kate at first, I sent the discovery and the plea to probation and parole. So they had the original pre-trial diversion paperwork prior to court. When we got to court, we realized he couldn't do a pre-trial diversion, and we had to change it to probation. And they just failed to change pre-trial diversion to probation.
I can see that. Yeah. But the funny thing about it is why would they have been doing a report anyway if it said pretrial diversion is what I'm saying.
Well, Your Honor, we don't have, there's no excuse for all. Some don't have.
Yeah. How much does this guy owe?
It's 5 years probated for 5 years, so pay child support in the amount of $206.50 plus an additional $100 per month. You apply towards arrears for total monthly payment of $306.50.
He's already a convicted felon. Is that right?
Yes, sir.
What were you convicted of?
Assault. That was happening in February. Since I've been outside, doing parenting classes, doing therapy, with my son, been paying on, for a full-time job, fixing moving supplies. I am guilty for being behind. You're coming, final sentence in 3 months, I can have this caught up and I won't have another barrel. Anyway, we can do that.
I don't have any objection to that. You want just continue it for 3 months, see if you can pay it off?
How will I continue 3 months if somebody, you stop paying off?
No.
Okay.
3 months, I should have it caught up.
Wait, we'll have, you'll be back here on November the 10th.
Okay.
If you're caught up, but then I think Commonwealth would be amenable and you show that you're straightening your life out and you're working and that sort of stuff. So I'll just postpone since. Oh, it is December the 9th. It's hard to believe that November is less than 2 months, isn't it? Yeah. December the 9th. She'll write that down here for you.
Last month I was here, you said something about me paying on court costs. Do I need to hold up on that? Or do I still need to pay it?
Yeah, don't pay it yet. If you pay that 5,000, you might beat us out of the court costs.
Give me this back.
Young man there. What's your name, sir? Yeah, speak up.
Mark Brown.
Brown? Is it George Michael? Mark, okay, I see Mark here. Commonwealth versus Mark Brown, 21 CR 0034. Mr. Brown, were you born in 1975? Last four digits, social security number 3114. 21 CR 0034 and 21 CR 0038. What we got going on here?
Felony plea.
I understand that you have filed a motion that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in the two indictments I just read?
Yes.
Is your judgment impaired today in any way? Have you discussed this matter with your attorney and you believe you're fully advised of all information about your case? You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront, cross-examine, and call witnesses to testify on your behalf to produce evidence, to appeal this matter to a higher court if you lose, the right to require the Commonwealth prove beyond a reasonable doubt that you're guilty. Do you understand that by entering a guilty plea today, you give up those rights? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation report from probation parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed. Now, if you all step to your left here, Mr. Judge is going to give what the offer is, see if this is what you agree to. And counselor, you need to let him listen to this, okay?
The Commonwealth recommends dismiss 21 CR 0003. Class 2 misdemeanor in possession of drug paraphernalia, class A misdemeanor. Also 21 CR 00038, possession of no first degree and operating a motor vehicle expired license and careless driving. Upon plea of guilty indictment number 21 CR 00034 for the charge of trafficking and controlled substance first degree, the defendant shall receive a sentence of 7.5 years, probation, 5 years supervised. The defendant should be referred to the Social Service Commission and follow any and all recommendations of the commission. The defendant shall forfeit $178 to Commonwealth Kentucky dispersed and towards the said forfeiture order submitted with this plea. The defendant shall receive credit for time served. The defendant should pay $1,000 fine and court costs at the discretion of court. The defendant should do a minimum of 30 hours to do community service or until gainful employment is obtained. The defendant shall remain on active supervision until all restitution, court costs, and further orders of court. The defendant agrees to have any and all contraband and controlled substances disposed of in accordance with the laws of Commonwealth and other cases.
Is that what you agreed to?
Yes.
You realize by entering this plea, you become a convicted felon on this charge. And in the future, if you have any additional felony charges, the sentence can be enhanced under persistent felony offender law. Do you understand that? Are you pleading guilty because you are guilty and for no other reason? Knowing your constitutional rights, I've explained to him, is it still your desire to give up those rights, enter a guilty plea and allow the court to fix your punishment as permitted by law? Is that your signature on the document? I'll accept the plea, order pre-sentence investigation report, and have you here on October 21st. Now, is there any time he's going to have to serve, or is it all probated?
I think the
7.5 years probated for 5 years. So it doesn't, it's not a split sentence or anything.
Any additional time on it, practically, proof of place of employment. Question. I don't have to teach any sort of, that's right, you work on that.
Okay, we'll see you back here on the 21st of October. You need to talk to probation parole officer. On the front row here. What's your name? You get behind. What is it? Still Alan Miller. When I called you before, it's Alan Miller then too. Adam Miller. Yeah. Commonwealth of Kentucky versus Adam A. Miller, 21 CR 0002. I think we already went through all the identifying things with Mr. Miller before. You have a plea now?
Yes, Your Honor.
Okay. Is this a felony pre or a diversion? Okay. Are you currently under the influence of drugs or alcohol, sir? Okay. Is this plea freely and voluntarily given? Are you the same person named in the indictment here? Is your judgment impaired today in any way? Have you had plenty of time to discuss this matter with your attorney and you feel like you're fully informed about your case? Okay, you have certain rights under the Kentucky and United States Constitution. I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to a speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, and the right to appeal this matter to higher court if you lose. You have the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea here today, that you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept it. Prior to accepting the recommendation, I will await the pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. Now, if you all move to the left here, Mr. Judge, what is the Commonwealth's recommendation?
Upon plea of theft of unlawful taking and disposition over $500, the defendant shall receive a sentence of 5 years. Upon the plea of guilty to burglary third degree, the defendant shall receive a sentence of 5 years. Upon the plea of guilty to criminal mischief first degree, the defendant shall receive a sentence of 5 years. 2 of the 5-year sentences shall run concurrently for a total of 5 years. The 5-year sentence shall run consecutively with the last 5-year sentence for a total of 10 years. Serve 180 days on home incarceration with the balance probated for 5 years supervised. The defendant shall receive credit for time served. The defendant shall maintain employment with Troy Builders Manufacturing. In the event the defendant does not maintain his employment with Troy Builders Manufacturing, he shall report immediately to probation parole. The defendant shall be permitted to travel with Troy Builders Manufacturing regarding work. The defendant shall pay court costs at discretion of court. The defendant shall remain on active supervision until all restitution, fines, and court costs are paid in full with further orders of court. The defendant shall have no contact with the victims. The defendant shall obtain gainful employment or do a minimum of 30 hours per week until employment is obtained.
Okay, you want to move behind the podium here? Is that what you agreed to, young man?
Yes, sir.
Okay, you're pleading guilty because you are guilty and for no other reason?
Yes.
Okay, so you enter a plea, waive your rights, allow me to set the sentence within the range permitted by law. You understand after entering this guilty plea, you become a convicted felon on this charge. And in the future, if you have any other felonies, they can be enhanced in the persistent felony offender law. You understand that?
Yes, sir.
Okay, is that your signature on there? Okay, I'll accept the plea order pre-sentence investigation report and have sentencing scheduled for October 21st. Let's go ahead, man. Okay, see the probation parole officer over here. Commonwealth of Kentucky versus Sky Williams, 18 CR 00169. You're Sky Williams. Okay, we're here today on a pretrial conference. What's the trial date on this? Okay, is there anything that we need to do to get ready for this trial, or are we ready to go? I mean, I know I don't have to do too much to get ready for it. Me and Sky just got to show up that day is all we got to do, right? So. What's he on the docket today, wonder?
I've never had one of those things since the federal testing. I don't know about you won't get too much right.
Who is that? And who, are there three folks going to be tried that day, or?
Yeah, Mr. Sky Williams, Trey Williams, and Mr. Sherman.
Okay. We'll see you on the trial date then. Sir.
Stacy Flippin.
You want
Stacy Flippin.
flipping? Cromwell versus Stacy Flippin. Stacy Joe Flippin, is that correct?
Yes.
21 CR 0048. We're here for a pretrial conference. A motion has been tendered that says you wish to enter a plea today. Is that correct? Okay. Well, you'll get a chance to go over it and see if you've agreed to it, or we can set a trial in. Quit apologizing to me. Okay, I know that you all got in a tough situation. We had on the docket that he was going to enter a plea today, but he said he's not aware of that and he hadn't looked at it. So you'll need to give him some time to look at the plea offer. And yeah. Do you have anybody in the courtroom, Mr. Hurt?
Judge, I have one client.
Are they in the courtroom?
Yes.
Okay, who is your client?
I had Commonwealth versus Diego Coloma, 21 CR 82. We have a resolution.
What page is it?
Please.
Twenty-one CR 0082, Commonwealth, Kentucky versus Diego Cuella. Is that correct?
Yes.
Mr. Cuella is born in 1989. Last four digits, of your social security number is 7943.
I think we clarified that last time. Those are not, he doesn't have a social security number, so it's not sure where those numbers came from. No, it's used to say giggle blow it.
Okay. Are you currently under the influence of drugs or alcohol? Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Should we freely and voluntarily?
Do we have a language barrier here that do I need a translator for him?
I don't think so. We won't do this this way. It's
Well, I want to make sure, you know what I mean?
no, we don't.
Mr. Crowley, do you understand the English language well enough to do this plea today? Okay. Have you discussed this matter with your attorney?
Have we discussed these papers?
I'm not going to do this. I mean, I just don't think it's fair to him to do it, Mr. Stockton, you know. I have to raise an interpreter. Well, come on up here. I'll just swear you in. You're a lot cheaper. You're a lot cheaper. I'm sure that you understand some of these things. Yeah.
He said he talked about the papers.
Yeah.
You understand,
Has he reviewed the evidence? Ask him if he's reviewed the evidence.
I want to see. He had gone.
Okay.
I spent a lot of days in Powder Patch.
And other places. And you survived all of it, hadn't you?
Yes, sir.
Yeah. Okay. Okay. He has certain constitutional rights. Okay. What is the Commonwealth's recommendation?
Your Honor, the victim would get Sullivan in this case, and the victim wants these charges handed down. The assault second, one conveyed for first, receiving the verdict of 5 years pretrial verdict, but the verdict they supervised, pay court costs, receive credit for time served, and maintain gainful employment.
Can you go over those terms with him? Can he read the language?
You know, that's thinking, you know, it's thinking.
He just can't understand me, he said it. Yeah. Yes, I understand these rest of these guys. I just can't understand. Okay. Is that your signature on there? what are the court costs here? $240. Does he need to take some time to pay that?
Good, Judge.
Does he
Yes, please.
pay it $40 a month, starting 30 days from today? He can either meet the probation and parole officer or go home with Mr. Bell, either one he wants to. Okay,
He's on ankle monitor, he's on the release.
yes.
Thank you, Judge.
Hey, you be peaceful. Don't be hitting anybody, getting any fights or anything. You know, best thing you can do if somebody tries to fight you is turn around and run. Okay? Okay. I guess that'd be vamoose. I don't know what that would be. Thank you, Mr. Bell. You were very helpful. Yeah. Mr. Hurt, I've noticed that Mr. Bell is awful helpful pleading your clients guilty. He's not so good at pleading his own clients guilty. Yeah. Okay, you want to do?
I've been able to meet briefly with Mr. Flippin.
Yeah.
I've been in discussions with Mr. Austin, however, he's requested a little more additional time to talk to him about all of the requirements of the plea agreement. I believe the plea agreement actually refers to it as well. I would make the court to allow him to have until October 21st, and he could actually attend the pre-trial meeting on October 1st. I feel like they're fairly close, and they might be able to work this out rather than schedule it how they need to.
Okay, he can be here with an attorney on October 1st, and he'll come back on 21st, okay? Okay, no problem. Okay, let's go back to you, sir, the powder blue there. What's your name, sir?
David Parker.
David Harper. Commonwealth versus David E. Harper, 18 CR 0026.
Commonwealth filed a motion to revoke, but Mr. Harper hadn't paid all the restitution, hadn't been paid, he's now paid in full, so we'll withdraw the motion.
Do you agree with him withdrawing the motion? That's the correct answer. Be on your way rejoicing. Okay, see you. Thank you. Good job, counselor. Okay, black shirt there. Would you identify yourself? Brown?
Yes, sir.
Okay. George Brown. 17 CR 0088 and 21 CR 0050. 888 is a motion to revoke, and the other one is a pretrial conference. Y'all have a plea?
Your Honor, I do have a note from Mr. Austin that there's a plea offer in the case. I'm not sure if he's had a chance to go over that plea offer with Mr. Brown. I was going to request an opportunity to step aside.
Okay, we'll come back to him. Make sure you have plenty of time, okay? Do you have anybody else in here, Mr. Bell? Okay. Mr. Gary, do you have anybody in the courtroom?
I don't judge my request.
What's your name? Pull over your nose here. Pull this over your nose.
Lord Hill.
Hill.
Hill, okay. Commonwealth versus Lloyd Paul Hill. 20 CR 0076. You're here today for sentencing. Is that correct? Have you had time to look at the pre-sentence investigation report done by probation parole? You haven't seen it?
Your Honor, please contact with that.
Okay, you need to give it.
Time to review it.
Yeah, go ahead. Take some time to review it. He can take a seat back there. Either one of y'all. I'm blessed. So what's your name? Leave it up. You can see anybody through these things, you know. I'm working Kentucky versus Truman Adams. This is 21 CR 0074, Commonwealth versus Truman Adams. Mr. Adams, you born in 1968, last four digits, social security number 1550. Y'all have a plea agreement in this case?
No, there's been a plea that has been extended. Not take my time.
Yeah, back away and make sure.
Your Honor, I was referring to Mr. Adams. I'm unsure that Mr. Austin has had an opportunity to discuss this with Mr. Adams. It looks like there's some discovery that
This is scheduled for trial on Tuesday.
is scheduled for trial on Tuesday. Your Honor, I just request to, if we can continue this in a trial date.
I can get my calendar come up.
I think we took it off yesterday.
What day was it scheduled
Mr.
for?
Adams told us, I mean, last told us.
It was scheduled for Tuesday.
Did we call the jury off yet?
Yeah, we continue to come to Mr. Austin. I think we've got everything. We're ready to try. Sometime later in the month.
Yeah, that was scheduled for this month, previous month.
Cisneros is supposed to settle itself on October 26th. So we want to say that.
Okay.
Hopefully,
Yeah, 26th and 27th of October, we have a trial. Okay, now there won't be any pleas now, okay? We have a trial. What's your name, young lady?
Leslie Jenkins. Leslie Jenkins.
Last name?
Jenkins.
Jenkins, okay. Como versus Leslie Jenkins, 21 CR 0049. We're going to pretrial conference. Y'all have a plea.
Information where they want for her to send her pre-trial conference. I did have an opportunity. And I believe that she truly did not realize that she had that pre-trial conference. I was going to request support about her opportunity to attend the pre-trial conference.
Did she not show up for a pretrial conference?
we filed a motion to bond because she didn't show on September the 3rd.
Well, I've got,
We've had, we had an order that she was supposed to be here on August 19th also. Order that she was supposed to be here on July the 2nd. And that order that she was supposed to be here on September the 3rd. I don't think that's been any.
I was here and the public defender gave me the paper, I mean, the card saying I'm supposed to be here today.
No, I'm not talking about court, I'm talking about negotiating.
I have a tendency to believe she's telling me the truth.
She's been on the distribution, has the clerk been sending them to her too, or just the her?
Look at the distribution last week.
We put the thing on there, I don't know if that address to send it to her.
Have you made an offer to her?
I've got an offer in the file, I think.
Yeah.
But, I don't know that everybody will convey it through negotiations. So.
Well, why don't you give her the offer and see what she said? What is the offer?
I saw that 4 years of traffic case where there was some mess there. If she would show up, then that would resolve our case.
Hey, you want her to come on October 1st?
I'm gonna try it one more time. and I'm gonna
Okay,
ask-
look at me.
I'm gonna ask the rest of
Look
the-
at me. Look at me here. If you don't show up on October the 1st and negotiate this thing in good faith, you don't have to enter a plea. But you need to tell the Commonwealth that you're not, and then we'll schedule a trial. You're entitled to a trial. But you cannot ignore these dates. You be there on October 1st and October 21st, or I'm going to revoke your bond. And it's going to probably be 6 or 8 months before you get to come back up. You understand what I'm saying? Okay. Thank you very much. Okay, do we have anybody else? You got Mr. Bell, who you got back there? Wait a minute.
She has an active warrant. They keep her in custody.
Hart is the last one.
Yes.
She said it's 6 months. 6 days.
96, that, no, right, 6 months.
Since you're supposed to be in Kroger, I said, Mr. Kraus and Mr. Baylor, same law.
Well, I didn't get this fixed.
Commonwealth of Kentucky versus Ashley Hart, 18 CR 00135. Motion to revoke shot probation.
Your Honor, we filed one because she is being supervised by Tennessee through ICOS. And she had a DUI and an attempted unlawful possession of a weapon, which is a class A misdemeanor. Mr. Bell says she served about 6 months in jail total on that.
How do you attempt, what's that table there? It's going.
Okay. Now she's in rehab.
How do you attempt to possess?
That was my question. I've never seen that charge. Where is she in rehab? Where is this place located? How long has it been?
I was in the faith-based facility for 3 months after I was released from Oakland County. I did 6 months in Oakland County total. And then after I was released from the islands and the faith-based, I moved myself into the hospital.
And that's the base. They've been supervised down there.
Yes, we get breakfast.
It's probation for all.
I keep calling them, they still have not, yes, we're going to that.
Okay.
Do you have somebody you can call down there?
I'm gonna withdraw.
I'd like just, while we got her here though, I'd like for our people to call and see why they're not returning her calls if she got the wrong number or something.
They changed my probation officer a couple of times. I don't know if I'm calling the other probation officer, but they changed the number out the order.
Are you working somewhere?
Is I work for the National Firefighting Association.
What do you do there?
I think it's a functions here.
Yeah, you're not one of these people that call me and ask me if I want to donate to the firefighters. Because I've been looking at opportunity for payback time on that. I can tell you that.
No, we don't have donations.
So you're not a phone solicitor then? Okay.
Mr. Collins, please explain this, how I work.
Your Honor, once we open the case up through our ICON system, I'm not allowed to make contact with any kind of probation officer or anything in Tennessee. But what I can do is she can report to me tomorrow. We can look at everything and I can get her a number and make sure we have the correct probation officer. We can even call while we're in the office. We can get as long as she calls and I don't. We can do that.
Well, you think you could step out here somewhere and call now with her?
Yeah, we can try it. I have to look on computers.
Well, why don't you do that? And I'd feel, I'll probably grant the Commonwealth's motion. I just feel a little bit more comfortable if I knew we were making sure you were in contact with them before we don't see you again, okay? If you step out, you can take her out this way. Mr. Bell, why don't you go with them?
Yes,
Okay. Okay, that seems to have everyone. We have this one gentleman back here. Have you, on the sentencing? You need to meet with him to go over that a little bit. Do you have any questions of your lawyers, sir? Okay, let's go, which jail will you go to? How many we have in Adair County?
One.
Let's go to Adair County Jail. What case do we have in Adair County?
Richie Lawson.
Adair County, Adair County Jail. Turn your microphone on.
I've asked him
How you doing? Commonwealth of Kentucky versus Richie Dean Lawson.
How you doing today?
I'm wonderful, wonderful. 21 CR 0054. We're here on a pretrial conference. Who represents Mr. Lawson? Public advocacy?
Yes, Your Honor.
Your Honor, it's myself, Candace Hill from DPA.
Okay. We're here on a pretrial conference. What do you have going on here?
Your Honor, me and Mr. Stockton negotiated a last minute offer for Mr. Lawson late yesterday. Mr. Lawson is planning on taking that offer, but we would need to set this until next month so we can get the paperwork and get it signed.
Okay, October the 21st. Okay.
Thank you, Your Honor.
Okay, thank you. Adair County, thank you for cooperating. We'll go next to the Barron County Jail, I guess. Okay, Barron County Jail. If you want to come up one at a time and identify yourself, y'all can do it in any order you want to.
Morning, Your Honor. Your Honor, my name is Michael Simmons.
What's your last name?
Simmons.
Simmons, okay. Commonwealth of Kentucky versus Michael B. Simmons Jr., 20 CR 0055. Mr. Simmons is here for arraignment. Is that correct? Piers, let me see here.
Yes, Your Honor.
Mr. Simmons, you're represented by the Office of Public Advocacy. You have the right to remain silent. The grand jury of Monroe County has returned an indictment charging you with tampering with a prisoner monitoring device. You have a right to remain silent. Counselor, acknowledge receipt of the indictment.
Yes, Your Honor.
The identity of this individual, Mr. Simmons, await formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
You want to schedule this for a conference on October 1st for negotiations, and the next court day is the 21st. Now, Mr. Simmons has been charged with tampering with a prison monitoring device, so I would assume it was one that he had on. So I guess you
That's
have
right. We had to put him in NCIC for some time to get him located.
Okay, so we'll do October 1st, and if there's a bond reduction motion, it'll have to be filed with proper notice. Thank you, sir. Next, who's next?
Oh, you look, I'm listening.
What's your name, sir?
Jonathan Wayne Burge.
Bird.
Hey. And Brenda.
Please don't be stressful.
Yes.
The trial date while we're here about. Sure. She'll know.
Commonwealth of Kentucky versus Jonathan Wayne Burge, 15 CR 0005. We're here today for the purpose of sentencing. Mr. Burge, have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason, counselor, that this gentleman should not be sentenced today? I don't see the plea agreement. Was he revoked? Final sentencing. Mr. Burge will be granted diversion for 5 years. She'll make payments of $200 per month until all arrears are paid. Looks like the diversion, wait a second. This is not right. It says diversion voided on July 22nd, 2021. So it's 5 years, we're sentencing to 5 years. What the Commonwealth have to say about this?
Just follow the recommendation, Your Honor.
5 years?
Yeah, it's a child support case that never was paid on. It goes, I don't know, $17,000, I believe. And we continued it 2 or 3 months to give him opportunity to see if it was going to be paid.
Okay.
Maybe the parole board can try to collect.
I couldn't really tell by the what.
Yeah.
Okay, you should be sentenced. Your pretrial diversion was voided on July 22nd, 22. Pre-sentence investigation report was done. You'll be sentenced to 5 years. Thank you. Thank you.
German Serrano.
You have to say your last name again.
Serrano.
Serrano, okay. Commonwealth of Kentucky versus Adam Serrano.
No. That's this scenario. I'm Serrano.
Toronto.
I can hear.
SERRO.
Yeah.
German Costello Serrano, is that correct?
Yes, sir.
Okay, 21 CR 0029. We're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Okay, is it correct?
Yes, sir.
Okay. Counselor, is there any reason this gentleman should not be sentenced today? Public advocacy representing this gentleman?
My representative, Bruce Brown, represents Mr. Serrano.
Who does?
Bruce Brown. I'm not sure if you're gonna accomplish or what.
Could you call Mr. Brown? You have Mr. Brown's number, phone number, somebody could call him?
I can, be in touch with my office.
Have you been in contact with your attorney, sir?
Not since last month.
So how did you get the pre-sentence investigation report to look at? How did you? So have you actually received a copy of this pre-sentence investigation report?
Yeah, I did, didn't I? Yeah, I did.
Who gave it to you?
I filled one out. Mandy Joe.
There you go.
I don't think so. He was going to be probated today.
I think he's being probation. Pleaded to stay.
Yes, he was gonna get credit for time served, be released. He's been in quite some time.
Please states he's to enroll in and complete an ARC rehab program.
Yeah.
So I don't know if he intends to-
Yeah, I don't know if probation's got that lined up yet or not.
But Mr. Brown does represent. Letting them know before they-
Well, it says 10 years probated for 5 supervised, assault fourth, 12 months concurrent with a burglary. Defendant shall enter into and complete rehab at ARC. Defendant shall pay court costs at the discretion of the court. Since today.
And this may be one that DPA was gonna get him into ARC. I'd have to look in the file, with Mr. Austin, because it seemed like they were gonna get a bid for him.
Are we starting to include in
Oh,
recommendation?
okay. He's conflict.
Are we starting to include in recommendations specific rehab organizations like ARC?
I did in this case because I thought that was something, and I'm wrong. This is Bruce Brown's client. I don't know why Mr. Brown's not here.
I'm here, Judge.
Okay, well, good. And did we have a
Would
conversation?
you
Mr.
join
Brown?
in, Mr. Brown? Have you been on there for a while or what's the deal? Turn your camera on, Mr. Brown.
Yes, Judge.
Would Russell County Detention turn your camera off?
Mr. Serrano was proceeding.
What did you say, Mr. Brown?
I believe Mr. Serrano was set for sentencing today.
Well, yeah, we've been here trying to sentence him and you haven't been here and you're not on the line. Okay, till now. Where have you been?
I was in the store. I was trying to get something done for my house. I apologize, Judge.
He's got it.
What about the rehab and the ARC? When's he gonna
Your
go
Honor,
in?
one reason I recommended ARC was that I know that's something probation and parole can use, and I know they're legitimate rehabs. A lot of these rehabs, they're not regulated, and until I check into them, I don't know who's a good rehab.
Okay, well, when is he gonna enter into the rehab?
Well, I guess after he's sentenced, Mr. Collins will have to try to see if he can get him a bed date. And if the Social Services Commission disagrees with us, I'll just have to live with it, I guess.
We can give you the session, Your Honor, and say the court recommends ARC. And, go back around.
10 years, probated for 5 on the burglary second, assault for 12 months concurrent with burglary charge. You shall go to the clinicians at the direction of the Department of Corrections, Probation, and Parole. What are the court costs here? $215. I'm gonna let you pay that at $40 a month, starting 30 days from today. Because you've been there for a while, I'm gonna get you a little chance to get back on your feet. You know what I mean?
Yes, sir. Thank you, Your Honor.
And you call probation and parole tomorrow. He will report over there tomorrow. Yeah, I'm gonna let him out.
Thank you, Your Honor.
Okay, now let me tell you something. I don't usually let people out till they get, but your attorney hadn't been here and you just kind of flying on your own here. So I'm gonna, you come in here tomorrow and report to probation and parole. And if you mess up just a little bit, we'll have you back in jail in no time. You understand what I mean? This is your chance to get out. I don't usually do it, but I'm gonna do it today.
Thank you, Your Honor.
Okay. Mr. Brown, next time you're scheduled to be here, you need to be here. You understand what I'm saying?
Yes, Judge, I understand.
Okay, thank you very much.
Thank you.
Thank you, Your Honor.
Yeah. Let's get next.
That's what I want to hear.
Terry Welch.
What's your name?
Terry Welch.
Terry what?
Welch.
Welsh.
He's being sentenced today too.
Commonwealth versus Terry Welsh. 20 CR 0037. Are you Terry Welsh?
Sir.
We're here for sentencing today. We had an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Okay. Is it correct?
Yes, sir.
Is there any reason why he shouldn't be sentenced today? I'm having a hard time. Okay, is this 5 years, probated for 5 years? Is that correct? I can't tell.
Since probated for 5 years, you can take up $1,000 to check it.
Yeah. Previous thing or not. Okay, you should be sentenced to 5 years, probated for 5 years. You'll pay $1,000 within 2 weeks of final sentencing, plus regular monthly payments of $298.50 plus $100 toward arrears. That's a total of $398.50 a month. The first $1,000, I'm going to do the first $1,000 and wait for 2 weeks to start the weekly payments. Is that what it? what we mean? That's what I'm gonna do. You pay $1,000 within 2 weeks. And then after that, you'll have monthly payments of $398.50. You understand that?
Yes, sir.
When does he need to show up for probation parole?
Release today and show up tomorrow.
You'll be released today and you show up probation parole tomorrow, okay?
Alrighty.
Okay, good luck to you.
Thank you.
Okay, let's have next.
Mr. Burge.
Burge.
I approve that.
Commonwealth versus Richard Burge, 21 CR 00088. Are you Richard Burge? We're here today for a pretrial conference. What do you got on this? Also 19 CR 0025, motion revoked.
Your Honor, I negotiated with Mr. Stockton on this case. We have not come to a resolution at this point. He did state yesterday that he may be taking some different action. And I don't know if that's his intent or not.
Mr. Stockton,
Your Honor, the facts of the case on the new indictment is that Mr. Burge was allegedly driving a vehicle and he was fleeing from the police officers, and then he ran off. The officers never observed Mr. Burge. Allegedly he was in the car with LaDonna Rich, who's currently on probation, and she stated that Mr. Burge was driving. Now it's my understanding that Mr. Burge and Miss Rich have kids together, and they're together, and she doesn't want to testify. She's saying that that's not what happened. So I guess I would just like to have a little time to talk to Miss Rich, and if that's going to be her situation, I'll know how to proceed in this case. Because if she doesn't testify on our behalf, I can't place Mr. Burge driving.
I have no objection, Your Honor. I would like to get Mr. Burge out of custody if we could.
so all these fleeing and evading charges, all this kind of stuff in 21 CR 0088.
It's based on Miss Rich saying that Mr. Burge was the driver and he fled. Now, I've not spoken to Miss Rich, and Mr. Bell says she said she'd rather go to jail than testify against Mr. Burge. I don't want to inaccurately quote.
We can arrange that.
We can arrange it. So I guess we could set a trial date and see what she says if we want to do that.
We could go ahead and subpoena her and you could bring her in.
Let's do that. I'll tell you what I'll do. I'll subpoena her and we'll have we'll hear the revocation motion based on her testimony, and I'll know then what to do about the trial.
I've also got an affidavit from someone who come in and stated that Mr. Burge, my client, was in Tennessee during the time that this took place. As far as LaDonna Rich in the revocation hearing, I've not seen any written signed statement nor a recording of the statement that she made. She has basically said to us she never made that statement. So that would be our position.
Well, we can have the officers subpoenaed too, along with Miss Rich, because they said they heard her say it. So
Okay.
there is no recorded statement.
Okay. October the 21st, we'll have a revocation hearing on Mr. Burge. She should be subpoenaed to be here.
Subpoena the officers too, Amber.
And subpoena the officers. I'll put her under oath if she wants to swear under oath that she never said that, she doesn't know this or whatever, then we'll know how to resolve the case. And the officers can testify and decide whether they want to go in front of the grand jury about her swearing a lie or not. Okay, thank you very much.
What about the bond?
What, Mr. Stockton, what's your position on the bond?
Well, if he is released, he needs to be wearing an ankle monitor, I think, based on these charges and how all this came about.
Judge, is this Richard Dale Burge?
Yes.
I'm showing that his probation was revoked on 8/19 and that he's a state inmate now. That could be wrong, but that's my note I have.
Chase, I've talked to Chase and Chase told me to contact him as soon as I got out.
Your Honor, as far as I know, he's not been revoked.
Okay.
You can talk to Mr. Stockton about this.
Yeah, I don't think that's correct.
Yeah.
Reflection, of course.
Who's next? State your name, sir.
Robert Lee Adams Jr.
Okay, Robert Lee Adams Jr. Commonwealth versus Robert Lee Adams Jr., 21 CR 0057. Are you Robert Lee Adams Jr.?
Yes, sir.
Born in 1975?
Yes, sir.
Last four digits of social security number 3267.
Yes, sir.
We're here on a pretrial conference. Who represents this gentleman? Office of Public Advocacy does. Okay, you can see your attorney there, Mr.
Yeah.
Adams. Okay. What do you have here, Mr. Stockton?
Your Honor, we've made an offer to resolve his case, and I don't know what the status is as far as the communication of the offer to Mr. Adams or what he wants to do.
Apologize, Your Honor, I'm not as up to date on Mr. Adams' cases. I would like to normally be.
You want you to speak? Well, hey, speak toward the microphone.
I apologize. And I don't seem to have an indication as to whether or not they are close to an agreement. I hate to request another pretrial conference, but I think Mr. Austin.
October 1st for a conference and next court date, the 21st. Next. What's your name, sir?
Monroe.
Say it again.
Clint Rowe.
Clint Rowe.
You want to give Lanny that plea, you can go in there and do that plea. Don't care. Or if I need to do it from here, I will. Here, I can do it. Just give it to me. Here, I can do it right here. Let me see.
It's Clinton George Rowe, is that correct?
Yes, sir.
Commonwealth Kentucky versus Clinton George Rowe, 14 CR 0016, a pretrial conference, and 11 CR 009. Are you Clint George Rowe?
Yes, sir.
You born in 1958?
Sir.
Were you born in 1958?
Yes, sir.
The last three digits is social security number 3810.
Yes, sir.
I understand that you have filed a motion saying that you want to enter a plea today. Is that correct?
Sir. Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Have you had plenty of time to discuss this matter with your attorney, and do you feel like you're fully informed?
Yes, sir.
You have certain rights under the Kentucky and United States Constitution. Before I can take a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, and a right to appeal this matter to higher court if you lose. You have the right to require the Commonwealth to prove on a reasonable doubt that you are guilty. Now, by entering a guilty plea here today, you give up those rights. Now, I may consider this is a felony plea or diversion.
Felony plea, Your Honor.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I do not have to accept a recommendation. Prior to accepting a recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Mr. Stockton, would you go over the offer?
Yes, Your Honor. Mr. Rowe would plead guilty in 11 CR 10 to theft by unlawful taking. He would receive a sentence of 5 years. In 11 CR 9, he would plead guilty to possession of controlled substance, first degree, 1 year. In 12 CR 5, he would plead guilty to manufacturing meth, a total of 10 years. All those would run concurrently for a total of 15 years, except the 5-year sentence would run consecutive, make it a total of 15 years. He would serve 180 days home incarceration, the balance probated for 5 years supervised. He'd pay a $2,500 fine and costs. The Commonwealth would recommend he be released at the plea if he's hooked up on a ankle monitor because of his health issues. And he would remain on active supervision till all restitution fines are paid and the all evidence in this case be destroyed.
We've just got 2 cases on the docket. Could you give us the numbers of those others?
Yes, there's 11 CR 10, 14 CR 16, 11 CR 9, and 12 CR 5.
Got him. Sir, is that what you agreed to?
Yes, sir.
Okay. Has anyone, including your attorney, offered you any other recommendation or threatened you in any way to get you to enter this plea?
No, sir.
Okay. Knowing your constitutional rights as I've explained them to them, is it still your desire to give up those rights, enter a plea, and allow the court to fix your sentence? You understand that by entering a guilty plea, any future convictions could be enhanced because of penalties. You understand that? Could be the penalty could be enhanced because you've entered these felony pleas. Is that right? And Mr. Stockton, why do we have all these old cases that he just now entered a guilty plea to?
Evidently, he never was served. They periodically check, and we just finally got him picked up. And Mr. Rowe's health has deteriorated considerably over the last 10 years. He's had a stroke. He also assisted the Commonwealth in a murder case back in 2005, and that's the reason I've shown leniency in this case, Your Honor.
Okay, well, we put an ankle bracelet on him today. He needs to be here. We're going to order a pre-sentence investigation report. He'll need to be here on October 21st for sentencing. Where are you going to stay between now and then, Mr. Rowe? Do we have an address for you?
Yes, sir.
Okay, well, somebody will be there today to set up an ankle monitor for you, okay? And then you'll need to make arrangements to meet with probation and parole to do an interview. Probably call them tomorrow. You have their number? Can they give the number to you there at the jail?
Sure they can. Yes, sir.
Okay. Chase, do they have your number there at the jail they can give to Mr. Rowe?
Yes, Mindy has it.
Just go ahead over here. Okay, well, they'll set the ankle monitor up and then give you the address. You call them tomorrow. Okay?
Okay.
Okay. Thank you a lot. Who's next? Next.
He's trying to get away from the podium, honey. Just say.
State your name, please.
Gary Miller.
Commonwealth versus Gary R. Miller, 21 CR 0007. Mr. Miller, were you born in 1974? What year were you born in, Mr. Miller?
74.
What's the last four digits of your social security number?
9580.
Okay, you're here at a pretrial conference. Do you have a plea in this case?
Your Honor, we do not have a plea worked out just yet. I was gonna move the court to continue this matter until October 21st. It does appear that we received an offer, but I'm not certain whether or not Mr. Austin's had an opportunity to go up that offer with.
Well, do you need to have him here on October 1st for negotiation, or you just want to go straight to the plea date?
October 1st would probably be the.
Okay, have him available on October the 1st to continue negotiation and be back here on October 21st for a plea.
I'm sorry, I was muted, Your Honor. We've got the plea papers finished, so I mean, I don't think I need him on the 1st.
Okay, we'll just do it on the 21st. I thought maybe if he had any requests.
Oh, if he's, yeah.
He hadn't reviewed it yet. That was the problem. The attorney hadn't reviewed it with him.
Okay, if they want to make him available, they can.
Okay, you can make him available on October 1st.
Thank you, Your Honor.
And the plea day will be the 21st. Next.
Who's that?
It's not going to change.
What?
No, jail credit.
John Lee Master.
Gary R. Miller. You have two cases. What's your name, sir?
John Lee Master.
Lee Master. Commonwealth versus John Michael LeMaster. John Michael D. LeMaster, 21 CR 0012. We're here today for a pretrial conference represented by the Office of Public Advocacy. What do y'all have to say in this case?
We need the negotiating day, Your Honor.
October the 1st for negotiations and October the 21st for the next plea day to enter a plea or set a trial. Thank you. Next.
Bradley Adams.
Bradley Adams. Commonwealth of Kentucky versus Bradley J. Adams, 20 CR 0070. Are you Bradley Adams?
Yes, sir.
Born in 1999.
Yes, sir.
Last four digits, social security number is 7015.
Yes, sir.
Okay, you're here today for a pretrial conference. What does the Commonwealth have to say?
We've typed plea papers, Your Honor. I don't know if they're ready or not. If they're ready to enter the plea or not.
The plea paperwork has been signed with Ray.
Okay. Ms. Hill, are you involved in this case?
Yes, Your Honor. Mr. Adams' case is actually my case, but I'm not able to be there with the plea paperwork.
Okay, they have it here for you. I think there's somebody else in public advocacy. Mr. Adams, are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in the indictment?
Yes, sir.
Is your judgment impaired in any way today?
No, sir.
Have you had plenty of time to review your file and talk to your attorney, and are you satisfied with her advice?
Yes, sir.
You have certain rights under the United States and Kentucky Constitution. Before I can take a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to a speedy trial by jury, the right to be represented by counsel, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence to call witnesses in your favor, and the right to appeal this matter to a higher court if you lose. You have a right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty. And you understand that by entering a guilty plea today, that you give up those rights. Now, is this a diversion or a felony plea?
It's a felony plea.
Okay. I may consider the Commonwealth's recommendation, but I do not have to accept it. I may apply any range of sentence allowed by law. If I do not accept any recommendation or decide to give you more time, you can withdraw your plea if you don't agree with that. Now, what is the Commonwealth's recommendation?
Your Honor, Mr. Adams is charged with possession of a controlled substance, possession of drug paraphernalia, and possession of marijuana. He will plead guilty to possession of a controlled substance, first degree, 3 years, probated for 5 years, supervised. He'll enter and complete the Monroe County Drug Court Program. He will pay all court costs at the discretion of the court. He will obtain and maintain gainful employment. All evidence in this case will be destroyed. When the meth was seized, also there was a Beretta handgun seized. There was no charges arising from that because he wasn't a convicted felon, but that'll be forfeit.
Is that what you agreed to, sir?
Yes, sir.
Has anyone, including your attorney, threatened or coerced you?
No, sir.
You plead guilty because you are guilty and for no other reason?
Sir.
You understand the persistent felony offender law that you're in future sentences
Yes,
will be enhanced. You understand that? Well, I'll accept the agreement, order a pre-sentence investigation report be done by probation parole. What was a release date on him?
You should get released when he's oriented. Has Mr. Mink assessed you?
No, sir.
Okay, we'll order him to, I guess you've already done a referral or will do a referral today.
Referral in the file.
They'll come over and interview you and we'll get you out of there into drug court as soon as we can, okay?
So you don't know when though?
Mr. Mink will have to come, he might do it online. I don't know when he's gonna do it, but we'll tell him to do it just as soon as he can. Okay?
Could the clerk advise me if the order was entered assessing him? We've got a copy, but we don't have a signed copy.
You look at the file.
It's probably be entered with the plea today.
Now, do they do the referrals before they enter their plea? I thought.
Yeah, that's what I'm saying. It's probably with the plea papers.
Okay.
Well, it was dated. We had it dated August. I thought it might have been already entered, but that's the reason.
I don't think they'll accept it after they enter their plea. There's a referral to drug court in those papers. What does it say? That's it. That's a referral.
That's it. Okay.
Yeah, I'll sign it. Mr. Bale, if you get that for him. I'll sign it. We'll get it to him today. Okay, he'll be over very quick, as soon as possible to orient you.
Thank you.
Okay. Okay, who's next?
Right here, my name's right here.
Commonwealth versus Eddie Ryherd. 20 CR 00066. Are you Eddie Ryherd? Here today on a pretrial conference. Representative of Public Advocacy. What do we have?
I told him, send me a great order and I never got it. Yeah.
What do we have here?
Oh, and I said,
You have a signed plea agreement?
Here's to be signed. By Mr. Ryder.
No. I don't need that. Not right now. So. Mr. Ryher, did you make a motion to enter a guilty plea here today?
Yes, sir.
Okay. Are you currently under the influence of drugs or alcohol?
Sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person indicted in 20 CR 00066?
Yes.
Have you had plenty of time to talk to your regular attorney about this and you feel like you're fully informed?
Yes.
Have you reviewed the evidence the Commonwealth has against you?
Yes.
Okay, now you have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you are fully aware of those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Do you understand that by entering a guilty plea today, you give up all those rights? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. If I do not accept the recommendation I will inform you that it's my intention to impose a harsher sentence after reviewing a pre-sentence investigation report. You have a right to withdraw your plea if I do that, if you're not willing to accept the harsher penalty. Mr. Stockton, would you recite what the offer is? And Mr. Ryher, will you listen very carefully?
Yes, Mr. Righthurd will plead guilty to burglary 3rd degree, receive a sentence of 3.5 years. He will plead guilty to theft, unlawful taking over $500, receive a sentence of 4 years. Those two sentences will run consecutively for a total of 7.5 years. He will serve 289 days in jail with the balance probated for 5 years supervised. He'll receive credit for time served and be released at final sentencing. He'll pay court costs at the discretion of the court. And once he's released, he'll obtain and maintain gainful employment.
Is that what you agreed to, sir?
Yes, sir.
Okay. Now, after knowing your constitutional rights, I've explained to you, is it still your desire to give up those rights, enter a plea of the charges, and allow the court to fix your punishment within any range permitted by law?
Yes, sir.
Okay. Now, I'm going to order a pre-sentence investigation report, and you'll be here on October 21st for sentencing, and I'll tell you what the court cost is and allow you to make some arrangements to pay that. Okay?
Your Honor, indicating that Mr. Dreyer seemed to waive his final sentencing. I don't know.
We can't do that. We can't waive final sentence. He's unless he's a state prisoner. Is he a state prisoner? Okay, thank you very much. James Scott. No, who else is ready there? To Barron County Jail. Who's next?
James Mercer.
James Mercer, 18 CR 00124. Are you James L. Mercer?
Yes, Your Honor.
You're here for sentencing. Do you understand that?
Yes, Your Honor.
You had an opportunity to review the pre-sentence investigation report done by probation parole.
Yes, Your Honor.
Is it substantially correct?
All of my knowledge, yes, sir.
Okay, Mr. Bell, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
He'd previously been granted pretrial diversion and that was revoked. Is that correct?
Yes, Your Honor.
Mr. Mercer. Just one question was, sent to rehab several times, or actually one's been on good that I know that he left. We want to send him back. That situation. So as plan. One thing the court was not aware of at that time, Judge, is that was the same rehab that he had left previously. And I won't take a lot of court's time. I know the business they did, but a lot of times these rehabilitation centers, one size doesn't fit all. And I believe Mr. Murphy can still be someone would benefit from going to rehab, and hopefully would be willing to go to that. I would ask for you at least consider him look at the SSC. The company in the day with the condition that he would get the help that I believe he needs to run back to the future.
Mr. Stockton?
Yes, Your Honor.
What do you have to say in response to what Mr. Bell just said?
I'm sorry, I didn't know he was talking. I didn't hear him. What did he say?
I in essence just asked that I tried to explain to the judge Mr. Marshall's situation as far as his revocation. And I brought up the fact that the rehab he was sent to that he didn't report to was the same one he had left previously. It's my position that all these rehab benefit, the same person, and that I was hoping that the court would look at Mr. Mercer, due to the fact that we got a considerable amount of time in jail, probate him today with the condition that he be seen by SSC, evaluated and complete rehab, where I believe he will be able to get the tools, the education concerning addiction, and hopefully not end up back here in the future. Without that, I don't believe it seems very difficult to stay away from old habits and old hands.
Your Honor, I would be opposed to probation at this time. However, if Mr. Bell wants to file a shock motion later on and Mr. Mercer has a plan as to where he'd go and what he's going to do, I'd probably look favorably on it.
Okay. To be sentenced 5 years. Fleeing and evading police, second degree. First degree. And then he also pled to fleeing and evading on foot and got 1 year. Is that correct? They'll run concurrently. And I don't see any other charges there. So
Has these charges in Barron County been resolved, or is it still serving on those?
I served him out, sir.
You served them out, okay.
okay, well, Mr. Mercer, the Commonwealth attorney, said that he would take a strong look at a shock probation thing as soon as you're eligible. Isn't that right, Mr. Stockton?
I will. I just want to plan where he's going to live, where he's going to work, where he can go to rehab. I think I need some of those details because
if you get that,
Mr. Mercer's going to get on the right track.
Okay, well, they'll start getting that package together for you, Mr. Mercer.
Okay.
Your attorney.
Appreciate it.
Next.
And then you stand over.
What's your name, please?
Shirley, Tanisha Shirley.
Say it again.
Shirley.
I can't say your full name.
Tanisha Shirley.
Tanisha Shirley. Okay, I can. Commonwealth Kentucky versus Tanisha Shirley, 18 CR 00192. Ms. Shirley, you're born in 1996.
Yes, sir.
Okay. Mr. Gordon, you represent her?
Yes, Your Honor, and I think this is just, I'm not sure what we're on the dock for. This is the companion case to the both Trey and Sky Williams, and we're just set for trial at this point.
Yeah, I don't know why you're on docket either. What, Mr. Stockton, do you have any idea?
I guess it was just set for a final pretrial before the trial is the only thing I can guess is why it's on.
Okay,
We've not filed anything.
okay, well, there'll be no pleas or other things then on this. We'll just go ahead with trial. Thank you very much. Okay, who's next there?
Kayla Spivey.
Commonwealth versus Kayla R. Spivey, 20 CR 0084. Ms. Spivey, were you born in 1992?
Yes.
Last four digits, social security number 9656. Is that correct?
Yes.
Okay,
We need her on the negotiation day on October the 1st, Your Honor, and we'll probably do a transport order to have her brought over.
October the 1st and then again on October 21st.
Yes.
October 1st for negotiation and the 21st for next appearance. What about this lady here, Chase? What about this lady that you checked on?
I'm still waiting on a phone number.
Okay, and this gentleman here, is he ready to enter a plea now, or he's sentenced? What? Sentencing. You want to bring him around, see if he's ready? What's his name?
Mr. Lloyd Field.
Mr. Hill.
I love Bill.
Commonwealth of Kentucky versus Lloyd Paul Hill, 20 CR 000676. Are you Lloyd Paul Hill? Okay, you born in 1966. Last four digits, social security number 3383. You're here today for the purpose of sentencing. Did I hand you that pre-sentence? Let's go. Hey, you need to get behind the microphone.
Mr. Gill indicates to me that there are some errors with his criminal history. Unfortunately, these are up to date, and I could not double check myself. But he says that, some of the.
What page you on?
Your Honor, he has indicated all of.
What page are you on?
On page 7, Your Honor, he's indicating. The real. Your Honor, he is indicating that on all of the criminal history, 7, 8, and 9 are not him. He does say that the criminal history on page 10 is him.
Your Honor, we'll get those.
Are you sure of that?
We'll look into them, you know,
Sure.
they are incorrect. NCIS, brought that up.
Okay, we'll take note of that and make corrections. If they aren't able to correct them, I guess we can allow a supplemental hearing on that at some juncture. Other than that, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On count 1, 5 years. On count 2, 3 years to run concurrently with count 1. Commonwealth agrees that the 3 years and 5 year sentence will run concurrently for a total recommended sentence of 5 years. probated for 5 years. Subject shall comply with sex offender registry, agrees to have any and all of her contraband destroyed. He should, what's the fine in this case? I mean, the court costs rather. Court costs $220. You need some time to pay that. You pay it at $30 a month, starting first payment 30 days from today. You shall pay up, remain on active supervision of your probation until all fines and court costs are paid. There wasn't any fines, is that right, Mr. Stockton?
Yes, Your Honor.
Okay. So you need to meet with a probation and parole officer. Now, if he's on the register, they will inform him where he can live and how he registers and things. Is that right, Mr. Stockton? Who will do the probation?
Yes.
Great. Thank you very much.
Thank you.
Yeah. Okay, this gentleman over here, what's your name, sir, now? Grant.
I'll go do this plea.
Commonwealth of Kentucky versus George Michael Brown, 17 CR 0088, 21 CR 0050. A motion has been tendered, sir, that says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily entered?
Yes, sir.
You were born in 1994.
Yes, sir.
Last 4 digits, social security number 2561.
Yes, sir.
Same in person named in the indictment, 17 CR 0088 and 21 CR 0050. Have you reviewed the evidence the Commonwealth has against you? Do you feel like you're fully informed about your case?
Yes, sir.
Are you satisfied with the advice of your attorney?
Yes.
You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at the jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, and right to appeal this matter to higher court if you lose. You have the right to require the Commonwealth prove beyond a reasonable doubt that you are guilty of the charges against you. Do you understand that by entering this plea, you give up those rights and allow me to sentence you with any range permitted by law? I may consider the Commonwealth's recommendation, but I may give you harsher punishment. If I do, you'll have an opportunity to withdraw your plea. Is that correct? Okay, you will move to your left significantly, and Mr. Judd is going to go over the offer.
Your Honor, please, the Commonwealth agrees to dismiss one conviction, second degree, dismiss reckless driving, and also possession of marijuana and possession of drug paraphernalia. On plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years, probation, 5 years supervised. The defendant shall enter and complete the Monroe County Special Program. The defendant shall receive credit for time served. The defendant shall pay court costs at discretion of court. The defendant shall remain on active supervision until all restitution, applicable fines, and court costs are paid in full and further orders of court. The defendant shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained. The defendant agrees to have any and all contraband disposed of in accordance with the laws of the Commonwealth.
Is that what you agreed to?
Yes, sir.
Now, you realize after entering this plea, you'll be a convicted felon, and any future felony convictions can be enhanced in the persistent felony offender law. Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'm going to order a pre-sentence investigation report be done. You'll be back here on October 21st for sentencing. You need to check with the probation parole officer over here so you get to see where there's information to give you. There was a revocation here. Is that correct? Is he to come back for sentencing on that, or is he supposed to go into custody?
Your Honor, that's being continued. He's going into drug court. He's in drug court, so I continued it with this new plea.
Okay, okay, thank you. Next, over there. Barron County. What's your name? Say it again.
Must be something wrong with the microphone. I can hear.
State it again.
Taylor Hill, you're
I've got to know that she can talk. Kayla Hill. Is that your name? Okay.
Her file.
Commonwealth versus Kaylee Sherry Hill, 21 CR 0075. We're here for pretrial conference.
Your Honor, Mr. Bell just got in this case, I believe, and he sent me an entry of appearance. She's in jail because she didn't appear in court on 8/19/21. I guess Mr. Bell needs to make arrangements to meet with me since he can't be here on the negotiation day on this case.
Jesse, I was going to make a motion that she be released on an ankle monitor pending resolution. I know that we were talking about that yesterday. That's something we could do today.
What kind of record does she have? Is anybody from pretrial on there?
I'm sorry, Judge. I'm
Miss
here.
Whitney soon to desert us.
Sorry.
What kind of bond does she have going on?
She's currently set at a no bond. She was served with a failure to appear warrant, as Mr. Stockton stated. Let's see, no bond. She's a moderate 3 for failure to appear, low 3 for probability to reoffend.
What kind of criminal record does she have?
Without running her actual record, I can pull up her pretrial report and look at it. That's showing that she's had no misdemeanor convictions, no felony convictions, at least one failure to appear within the last 2 years, at least one failure to appear outside the 2-year mark, no violent offense convictions, and no sentence to incarceration. So minimal.
What do you say about that, Mr. Stockton, as far as her bond is concerned?
I would just ask that if she makes a bond, it'd be a secured bond along with the ankle monitor. The charges in this are pretty serious. She had 11.7 grams of meth according to the report. I need a lab report, and it was concealed in her car. So it's not a run-of-the-mill possession case.
Well, because of the quantity and the fact that it was in her vehicle, I have some reservations. You want to negotiate that some with the Commonwealth? Maybe we'll take a look at the bond. You want a hearing on it? It's what you're saying, Mr. Stockton? If we do?
Yeah, I think if we can't negotiate it out, then I think she's entitled to a hearing on it.
I would be amenable to accepting a lower bond if you had an ankle bracelet and stuff. So y'all send me an agreed order if you can agree on it, okay?
Okay.
Okay, next. You got somebody in the Barron County? Who do you have? Okay, wait till we finish this. State your name, please.
Brian McHugh.
We check and see.
McEwen.
Let's see.
Brian Neal McHugh, 21 CR 0064. Are you Brian Neal McHugh?
Yes, sir.
Born in 1969. Last four digits of social security number 5121. What do we have here?
Your Honor, this is Mr. Austin's case. I would move the court to continue his case until the October 1st date and the October 21st court date. In between that time, I'm not sure what pretrial. It's my understanding that Mr. McKee incarcerated for a period of time.
Just Whitney, what do you have to say about how long he's been in and what is?
I'm showing Mr. McHugh was booked in on June 18th. Bond is currently set at 25,000 cash with an ankle monitor to be in place before release. No further violations of the law. Make all scheduled court appearances. No use or possession of illegal drugs or alcohol. His risk assessment came back as a moderate 3 for failure to appear, moderate 8 for probability to reoffend. Let's see, I'm showing that when this occurred, he was charged with a new offense while having a pending case. And then a prior misdemeanor conviction, prior felony conviction, FTA outside the 2-year mark, 1 prior violent offense conviction, and a sentence to incarceration.
What do you have to say, Mr. Stockton?
I've offered 2 years to serve on possession. If he doesn't want to take that, we can have a trial date, get him a quicker trial date. If he can't make the bond, if he makes a secured bond with ankle monitor, that'd probably be all right. But he, I don't know what he's going to do if he gets out, if he's got a job or what his plans are or anything.
Do you have a job lined up to get out?
Yes, my boss has done so. Last month I told y'all, he said he would sign me out and I'd do the ankle monitor or whatever.
Okay, I'm gonna change it from $25,000 cash to $25,000 a secured bond with an ankle monitor. And we'll let you out today on that thing. And then we'll bring you back here on October the 1st for negotiation. And then October the 21st for a plea. And you heard the offer. What kind of criminal background does he have recently?
I'm showing a pending case out of Hart County.
What is it? What is that?
Give me 1 second. I'll pull it up.
I've done pleas on it, Your Honor. They dropped the felony case over there and a DUI with an appeal.
Okay.
So I've done all that.
Okay.
I think I have pending in Monroe County.
Okay, well, you be
I'm on probation. I'm on probation with Chase also out of Barron County.
Okay, well, we'll see what happens on October 1st and see if we can wrap it up on 21st.
Judge, I want to make sure I understood that modification. Did you say 25,000 unsecured or surety?
Surety.
With an ankle monitor, okay.
An ankle monitor. He said his boss would sign him out, so a $25,000 surety shouldn't be too hard to make.
All right.
25,000 surety and an ankle monitor. Now, if he's got a job and if he's on probation, I'm sure the Commonwealth will consult with probation and parole as to the probability of adding this on to his other sentence or whatever you need to do, Mr. Stockton.
Yes.
Chase, has he been pretty compliant?
He's always been compliant.
He says he's always been compliant and cooperative, so maybe we can work something out and get this past him. Always helps you to work, Mr. McHugh, and at least tell everybody there in the jail if someone can keep a job.
I was also enrolled in 6 months outpatient through Chelsea Welch.
Okay.
They haven't had me in here on indictment since then. Can I just have Craig, because I don't know what he'll have on the signing out. Can I just get him to sign me out and do the ankle monitor?
I don't know him, but if he, $25,000 surety is not, if he's got a car paid for, he can sign 25. It's not a property bond.
Okay.
You just have to come in and sign an affidavit that he's worth $25,000 clear of other things. And he can sign you out and then we'll put the ankle monitor on.
All right.
Okay. Good luck to you.
All right. Thank you.
Next.
Robert.
Pardon?
Robert and Eric Stevenson.
Robert Stevenson. Robert D. Stevenson, 21 CR 0056. Are you Robert Stevenson?
Yes, Your Honor.
Okay. You born in 1986?
Yes, Your Honor.
Last four digits, social security number 0778.
Yes, Your
Okay,
Honor.
it's a pretrial conference.
Your Honor, he has this case pending here in Monroe County. He will be arraigned on a new felony case in Cumberland County next week. I don't know if he wants to have them both transferred to the same county. We could transfer this one to Cumberland County and try to wrap them both up.
Yes, Your Honor. I was hoping to be arraigned today out of the Cumberland County. They didn't come get me last month.
Yeah, you're on for this month on the docket already. It'll
Okay,
be next Thursday.
We'll arraign you there. When do you have a conference day set up? Before Cumberland County?
Be October the 15th. Well, no, actually it's tomorrow, but next month will probably be the 15th of October.
What's our court day over there next month?
The 28th.
See, I was wanting to try to get you in a negotiation day before the next rule day.
Yes, I think I've come to an agreement on both cases. I just had arraigned on the one.
Well, we can try to leave it here and I can. Yeah, I just thought with the problems with the sickness in the Glasgow office, I might get it done quicker if it was transferred to Cumberland County. But
I think you would. I think you would. When's the rule day over there is when?
It's just going to be a week later on the 28th.
28th, and we could probably wrap you all up because they got COVID in the public defender's office in Glasgow, and it could be a while before you get somebody. So we'll schedule you on the 28th, hoping to roll the whole thing up on the 28th. Okay.
And just can we transfer this case then to Cumberland?
If you have any objection to transferring this case to Cumberland, get it over. Okay, we'll transfer 21 CR 0056 to Cumberland County for the purpose of judicial economy and under agreement between the parties. Okay.
Okay.
Yeah. Mr. Okay, next.
Ben Tooley.
Pardon?
Benjamin Tooley.
Tooley, okay. Benjamin Tooley. 21 CR 0092 and 20 CR 005. We're here. A motion to revoke and a pretrial conference.
Your Honor, there's also a case going to the grand jury today on Mr. Tooley. I'll give, if Mr. Bell is going to represent him on that, I'll send him the discovery and have him schedule a time to talk about all three cases if he wants to.
That's what we talked about yesterday. We just wait for.
Okay, there's another indictment coming, Mr. Tooley, evidently. So what they're going to do is go ahead and send the discovery on that to your attorney, and you can work on all these cases at once. And you're not going to be able to be here on October 1st, right?
No, but I'll meet prior to that.
Well, Mr. Bell will tell you what day that there'll be a meeting set up with the Commonwealth and you to negotiate these things. And you'll be back here in court on October 21st. Thank you. Next. State your name, please.
John Bryant.
Bryant. Commonwealth versus John Casey Bryant, 21 CR 0042. Are you John Casey Bryant?
Yes, sir.
Okay. Born in 1981.
Yes, sir.
Last four digits, social security number 9773.
Yes, sir.
Here today for the purpose of arraignment. You're represented by the Office of Public Advocacy. You have the right to remain silent. The grand jury of Monroe County has returned an indictment charging you possession of drug paraphernalia, possession of marijuana, and possession of a controlled substance in the first degree. You understand those charges?
Yes, sir.
Okay. Counselor, you acknowledge the identity of your client, receipt of indictment, wait for more, you can arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, sir.
Okay, what's Mr. Bryant's bond situation, Ms. Whitney?
Mr. Bryant is, second. I'm showing that he set it a no bond and has a parole hold.
He's saying,
State inmate then, so we'll have him available for negotiation on October 1st, and then here have a plea day or set a trial on October 21st. Okay, thank you very much. Next.
Thomas Ludwig.
Ludwig,
Sir.
Commonwealth Attorney versus Thomas Ludwig, 20 CR 0083. Are you Thomas Ludwig?
Yes.
What year were you born, Mr. Ludwig?
71.
And what are the last four digits of your social security number?
2886.
Okay, you're here today for the purpose of arraignment. You're represented by the Attorney Office of Public Advocacy. You have the right to remain silent. The Grand Jury of Monroe County has returned an indictment charging you with failure to comply with the sex offender registry and being a persistent felony offender. You understand those charges?
Yes, sir.
Okay, Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions? Okay, I'm going to do a reciprocal discovery order today, Mr. Ludwig, where they have to give you the information they have about it. I'll set a negotiation day of October 1st and the next trial date on October 21st. Rather, not trial date, rather than next appearance. Both of those are conditioned your bond, October 1st for negotiation and 21st for the next appearance. Okay, who's next? You're welcome. Have a good day. What's your name, sir?
Danny Neal.
Neil, Danny W. Neal.
Yes, sir.
21 CR 0007, Commonwealth, Kentucky versus Danny Neal. Mr. Neal, you born in 1972.
Yes, sir.
Last four digits, social security number 0868.
Yes, sir.
Okay. Okay, we're here today for a pretrial conference. What have you got in this case?
I've got a felony plea paper prepared. I don't know if it's been executed or not.
Yes, sir. I talked to my lawyer here the other day and because my dad is sick and he said that you, Mr. Stockton, that you agreed to let me out for 7 days if I sign a plea guilty for 5 years. And he's not been back up here, but I want to sign it today. And that way I can, but I don't really need 7 days. If I can get out today, I can get my, I've got my stimulus money that was put on the card due to my wife passing. And I've got it worked out now that all I've got to do is get out and put the money over on another card so I can pay off the restitution and be out for like 3 days. And then I can come back up here because I want to get this out of the way. You know, just let me out to get this, the restitution squashed and get my home payment. Cause my lawyer, I told him I just need just a couple of days and I'll come right back and get it done, you know.
Mr. Austin had mentioned that to me, and I was going to sign an order for a 7-day furlough if it's all right with the court, but it never got done, I guess, because he got sick.
Oh, well, I mean, my dad's sick now.
He's got to admit, your attorney has the COVID is the reason he's not been back with you. So we're going to try to follow through at least in the spirit of that sort of stuff. So, you know, so you're going to give him a 7-day furlough.
Yeah. But now somebody, I told Mr. Austin, somebody needed to sign a surety bond or something for him. I mean, turn him loose.
Can I get approved unsecured bond? My mother said she would sign it, but she don't have no money. She just I just need her, Tammy Smithson. That's
Well, there's no, if it's unsecured, there's no reason to have her sign the bond. Does she own a car?
Yeah.
Is it paid for?
Yeah.
Okay, what's the car worth?
I don't know. It ain't worth. probably $1,000 probably. I mean, it's just it's an old money
It's good
car.
enough, Judge.
Okay, I'll let your mother sign $1,000 surety bond.
So she don't have to have no money, just come up here and sign it?
No, but if she signs it and you violate, we'll take her car.
Well, no, I won't do that. They're sick now, but I can get her to come up here and sign it because I'll have to take care of my
Now you
dad.
have $1,000 bond, you have a 7-day furlough from today. And then when you get all that settled, we'll bring you back here on October the 21st to wrap all this up, okay?
Yeah, we probably want to put him on October 1st too, so.
October 1st for negotiation of your case. Wait, no, you let me talk and then you can ask me a question. You'll be back on October 1st for negotiations. And then you'll be back on October 21st. The 7 days will start as soon as I can sign the bond. So I won't let you miss a day because I don't get the bond signed till tomorrow. You understand what I'm saying?
Okay.
Okay, we'll let you out just as soon as we can for you to take care of your family business. Have your mom come up there and sign $1,000 surety bond, okay?
I'll have her today, sir.
What's mom's name?
Tammy Smithson.
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 Got it. All right, thanks.
All right.
Yeah, you'll need to turn yourself back in at the end of that 7 days, okay?
Thank you, sir.
Okay. He's got a stimulus check to do the restitution. Next.
Derek Graves.
Derek Graves.
Yeah, I need that. And I probably, if Chase needs to come in here, I need to go in there.
Yeah.
This is like the longest day ever today. Commonwealth versus Derek Graves, 18 CR 00176. A motion to revoke. Are you Derek Graves?
Yes, sir.
Will you get somebody to go back there and turn the camera off on Mr. Stockton back there? We can do it. Okay. Okay, it's done. What do you have?
This is a motion.
Okay, ma'am, if you'll move to the left here and let him have the podium. What, you got something you need to tell me?
Yeah, this is a motion to revoke probation. We had a hearing on Mr. Gray, we had a violation. And then when he got out, he overdosed and I filed another.
Mr. Collins, you will come up and raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth. Okay, go ahead.
Unfortunately, I won't have an opportunity to meet. I would be 14. Just getting your understanding. Not an opportunity to meet with them. I have to let, I can.
That's fine. We'll continue this to the October 21st. Yeah, there's a pin, October 21st. Who's next? Mr. Graves, they continued your case to October the 21st because your regular attorney was ill with COVID, and this attorney is going to come and meet with you so you can prepare a defense to the motion, okay?
The other thing I was going to ask if I could get treatment for my addiction. That's all.
We'll address that later, okay? Okay, yes, sir.
Jeremy Jones.
Jones?
Yes, sir.
Jeremy Jones, 20 CR 0072. Are you Jeremy Jones?
Yes, sir.
Okay, we're here on a pretrial conference. You born in 1979?
Yes, sir.
Last 4 digits social security number are 5671.
Yes, sir.
You also,
Yeah.
We also got 21 CR 0076 too. Tampering with a device, terroristic threatening, wanton endangerment, 2 counts. What do we got, Mr. Stockton?
We have prepared a felony plea, Your Honor. I don't know if it's been signed or not.
I signed it, sir.
Okay.
You have a copy of it, counsel? He said he signed a felony plea.
Yes, Your Honor, I do have a motion on that offer of plea guilty.
Okay, a motion has been tendered that says you wish to enter a plea guilty today. Is that right, Mr. Jones?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in 20 CR 0072 and 20 CR 0076?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney?
Yes, sir.
Are you satisfied with her advice?
Yes, sir.
You believe you had an opportunity to look at all the evidence in your case? You feel like you're fully informed?
Yes, sir.
You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Have your right to speedy trial by jury, the right to be represented by counsel as your jury trial, the right to confront
You do it.
witnesses called.
Well, this, I think, let me do this.
Right to produce
That's on the
evidence.
time, sir.
Mr. Stockton, turn your microphone off while I'm doing this thing, okay? You have a right to call witnesses in your favor, have process issued to compel their attendance. You have a right to appeal this matter to higher court and require the Commonwealth to prove beyond a reasonable doubt that you are guilty. By entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any sentence or any range of sentence provided by law. If I give you more than they recommended or that you agreed to, then you can withdraw your plea. What is the recommendation, Mr. Stockton?
Your Honor, Mr. Jones will plead guilty to, in 20 CR 72, to the charge of terroristic threat in 3rd degree. He'll also plead guilty in 20 CR 72 to wanton endangerment 1st degree, 2 counts, receive 4 years on each count, run concurrently for a total of 4 years. In 21 CR 76, he'll plead guilty to tampering with a prisoner monitor device, receive a sentence of 3 years. Those 2 sentences will run consecutively for a total of 7 years. Mr. Jones will serve a total of 471 days, and will be his total jail credit, the best we can calculate at final sentencing, and he'll be released at final sentencing. He'll have no contact with either victim in this case. Defendant shall pay court costs at the discretion of the court, and once he's released, he'll obtain and maintain gainful employment.
Is that your understanding of the Commonwealth's offer?
Yes, sir.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Knowing your constitutional rights, if I explain to you, still your desire to proceed.
Yes, sir.
You know that you'll be a convicted felon and these could be used against you in any future felonies. Is that right?
Yes, sir.
What is the court cost? Your court costs are $245.50. You can start making $30 a month payments 30 days after you're released. I'm order a pre-sentence investigation report to be done by probation and parole. Will set your sentencing on October the 21st.
Can I waive that, sir?
No, is he a state prisoner? He's not a state prisoner, is he?
No.
No, you cannot waive it. We have to do it. Okay. Thank you very much. See you then. Next. What's your name, sir?
Chris Denton.
Pardon?
Chris Denton.
Stanton is his name?
Denton.
Denton. Trouble with his consonants. Commonwealth of Kentucky versus Chris Denton, 19 CR 0091. Are you Chris Denton?
Yes, sir.
It's 18 CR 00137 also. You're on a motion to revoke shock probation and on both of these cases. What's the Commonwealth have to say?
Your Honor, the basis for the revocation is a new felony case on possession, and that's been presented to the grand jury today. If we could have the October 1st negotiation day and the next motion day, I'll furnish discovery to defense counsel.
Mr. Denton, you understand that they presented a case to the grand jury involving you today. So what their suggestion is bring you back on October 1st for negotiation and October 21st for your next appointment. So you can try to roll all of it into one. Okay? Thank you very much. Nick.
Next.
What's your name, sir?
You're welcome, honey.
Pardon?
Axel Williams.
The first name, so. He doesn't appear to be on the docket.
What did he say? His last name was Williams?
Are you saying Edsel? Ansel Williams. Ansel Williams, like the artist. Why do we have Mr. Ansel Williams here? Does anyone know? Ansel Williams. Like the artist. Somebody
I'm
check.
showing he was arrested on September 2nd for 15 CI 6.
Civil case, child support civil.
Child support civil.
I have money to pay on
Where's he going? Is he serving contempt time?
Yeah, it's a civil. He got arrested on a
Yeah, but I
civil.
mean, how much is it to purge? What I meant to ask.
I don't have any.
Somebody look up this, it's a civil case, see what it would take to purge.
$15,545.35 is what's showing on the warrant.
There should be a court order somewhere that says how much to purge. Usually you don't have to pay the entire amount to purge.
I've been trying to get set up for surgery. I have a hernia that's too far. It's ready to burst.
Says $16,570.35, and you can walk out of there.
Have that, sir, but I mean, I can get some money paid on it.
Well, I mean, evidently that's been a problem over a period of time. So you're not indicted. This is a civil thing. And so you can walk out of there today if you pay the amount off, okay?
I can't come up with that much.
Well, you need to contact the county attorney's office. They'll let you use the phone and you call the county attorney's office in Monroe County, okay? Okay, thank you. Next.
Cisneros.
Pardon?
Adam Cisneros.
Okay, good. Cisneros, 21 CR 0063. You're represented by. Okay.
There's a resolution.
Okay. Mr. Cisneros, were you born in 2000?
Yes, sir.
Last four digits of your social security number of 4611.
Yes, sir.
Motion's been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in the indictment?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you had plenty of time to discuss this matter with your attorney and you feel like you've been fully informed?
Yes, sir.
Were you satisfied with his advice?
Yes, sir.
You have certain rights in the Kentucky and United States Constitution. Before I can accept a plea, I need to know if you fully understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, and the right to appeal this matter to a higher court if you lose. You have the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. You understand that by entering guilty today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may also apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose harsher sentence, you have a right to withdraw your plea of guilty. Now, what is the Commonwealth's recommendation? Just step to the left there. Mr. Judd, listen very carefully, Mr. Cisneros.
Your Honor, please, the Commonwealth agrees to dismiss 21 CR number 1, speeding, reckless driving, improper passing, failure to signal, and road penetration. Under 21 CR 63, criminal intent, also dismiss criminal intent to commit murder. And then under indictment number 21 CR number 1 for the charge of pleading evading police, first degree defendant shall receive a sentence of 5 years. Under indictment number 21 CR 1 for the charge of wanton endangerment, the defendant shall receive a sentence of 5 years. Under indictment number 21 CR 1, the 2 5-year sentences shall run consecutively for a total of 10 years. Under indictment number 21 CR 1 for the charge of operating a motor vehicle with alcohol concentration higher or above 0.08 while under the influence of alcohol or other substance, the defendant should pay a $200 fine plus court costs. Under indictment number 2163 for the charge of assault third degree, the defendant shall receive a sentence of 5 years. Under indictment number 21 CR 63 for the charge of wanton endangerment first degree, the defendant shall receive a sentence of 5 years. Under indictment number 2163 for the charge of receiving stolen property over 10,000, the defendant shall receive a sentence of 10 years. Under indictment number 21 CR 63, the 2 5-year sentences and 10-year sentence shall run concurrently for a total of 10 years. The 10-year sentence indictment number 21 CR1 and the 10-year sentence indictment number 2163 shall run concurrently for a total of 10 years to serve. The defendant shall receive time for credit. The Commonwealth proposes probation. The defendant shall pay a fine and court costs discretion recorded in both indictments number 21 CR1 and 21 CR 63. Under indictment number 21 CR 63, the defendant agrees to forfeit 2 Glock 40 caliber magazines, 15 live 40 caliber rounds listed as item number 4 and 5 of the KSP 41 of the Commonwealth of Kentucky and disposed of in accordance with the laws of the Commonwealth and the holding agency, or to be tendered after final service. Under indictment number 21 CR 63, the defendant agrees to dispose of all Win 40 Smith Wesson kitchens and major cartridges and lead listed as item number 404-1 through 404-9 of the KSP 41 of the Commonwealth of Kentucky, disposed of according to the laws of the Commonwealth. Under indictment number 21 CR 63, defense counsel agrees to the release of the 2018 Toyota Tacoma listed on KSP 41 item number 1 to the appropriate owner, order to be tendered final hearing. Under indictment number 21 CR 1, the defendant agrees to forfeit single action, revolver pistol, and 9mm bullets to Commonwealth of Kentucky, disposed of in accordance with the Commonwealth holding agency, order to be tendered after final sentence.
This is what you agreed to, sir?
Yes, sir.
Yeah, I'm going to order a pre-sentence investigation report done by probation parole. You realize after this plea, you'll be subject to having any future felony pleas or convictions enhanced on the persistent felony offender law. I don't think there's a driving under the influence thing, is there? Okay. Now, I'm going to have this pre-sentence investigation report drawn back here, and you could.
There is one under 21 CR1.
I thought there was. I don't have all the sheets here. Okay. Also, on a DUI case, that can be enhanced also if you get a new DUI, and the penalty will be more for a second offense or and third offense and all subsequent offenses. Do you understand that? Okay, I'll tentatively accept the plea subject to a pre-sentence investigation report done by probation parole. I'll bring you back here on October the 21st for sentencing. Files canceled. Okay. I'll announce court. I'm going to combine the court costs and several of these things to what the pay gets out. October the 21st. Regular day. Next. What's your name? Wait just a second. What's your name?
Ezekiel Turner.
Turner? You say Turner?
Yeah.
Commonwealth of Kentucky versus Ezekiel Turner, 21 CR 00066. Are you Ezekiel Turner? Are you Ezekiel Turner?
Yes, sir.
Okay, we're here today on a pretrial conference. What do we have?
Your Honor, I believe we need a negotiation day. I think Mr. Turner showed up. The last one was under the influence. So I would ask that we have October the 1st and the 21st.
Yeah, October the 1st for a negotiation day, Mr. Turner, and October the 21st for your next court appearance and possibly a plea. Thank you very much. Who's next?
Young.
What's your name?
Young. Tyler Young.
Tyler Young, did you say? Commonwealth versus Tyler Young, 21 CR 0025. Mr. Young, were you born in 1988?
Yes, sir.
Last four digits of your social security number are 9023. Is that correct? Okay. We're here today for a pretrial conference. What do we have in this case? A motion has been made that says you wish to enter a guilty plea today. Is that right, Mr. Young?
Yes, sir.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person named in indictment number 21 CR 0025? And 21 CR 0081, is that correct?
Yes.
Is your judgment impaired today in any way?
No, sir.
Have you had time to discuss this matter with your attorney? You feel like you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and the United States Constitution. Before I can accept a plea of guilty, I need to know that you fully understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. Understand that by entering a guilty plea today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I also may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting your recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Mr. Stockton, what is the Commonwealth's recommendation in this case?
Your Honor, in 21 CR 81, he will plead guilty to charge of possession of a controlled substance, first degree, receive a sentence of 2.5 years. In 21 CR 25, he'll plead guilty to charge of no insurance, be a $500 fine and cost. Also in 21 CR 25, he'll plead guilty to operating a motor vehicle under the influence of other substance, first offense, aggravating circumstances, pay a $300 fine and cost and serve 4 days in jail. Upon a plea of guilty to 21 CR 25 possession of controlled substance, first degree, he'll receive a sentence of 2.5 years. Both 2.5-year sentences in both cases will run consecutively for a total of 5 years. He'll serve 120 days in jail total, pretrial diverted for 5 years, supervised. The 120 days on the possession and the 4 days will run concurrently for a total of 120 days in jail. He'll receive credit for time served, remain on active supervision until all fines and court costs is paid, and obtain and maintain gainful employment once he's released, and all evidence in this case will be destroyed.
Is that your understanding of the Commonwealth's recommendation, Mr. Young?
Yes.
Okay. Has anyone, including your attorney, offered any other recommendation or benefit or threatened you to get you to do this sentence? Has anyone threatened or coerced you or offered you anything else to enter this plea? Okay, you're pleading guilty of your own free will because you are guilty. Is that correct?
Yes.
Did you sign this motion and offer?
Yes.
Yeah, I'll agree. I'll accept the agreement subject to pre-sentence investigation report done by probation and parole. You'll be back on October the 21st for sentencing. Who's next there?
Hey.
Jesse Hedrick.
Say your last name again.
Hendrick.
Hedrick, is that correct?
Hedrick.
Commonwealth of Kentucky versus Jesse Hedrick, 20 CR 0032. Are you Jesse Hedrick?
Sir.
Okay, you're here today for sentencing. Do you understand that?
Yes, sir.
Have you had an opportunity to read the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason why this gentleman should not be sentenced today, Counselor?
I know, it's no reason not.
Okay. You received 5 years on 20 CR 0032, served 6 months home incarceration subsequent to final sentencing. 5 years consecutive to count one for a total of 10 years, served 6 months home incarceration subject to final sentencing with a balance probate for 5 years. The charges are best. Now, is this 1 6-month period or is it 6 months on each one of them, Mr. Stockton?
It'd be concurrent for 6 months.
Okay. Okay, well, I will get the sentencing finished, but you'll probably need at some juncture. How much time? It's 6 months from today, right? It said subsequent to sentencing. Is that what it says?
Let me look real quick. See.
Whenever he gets hooked up on.
Attorney Jesse Hedrick.
And so they'll hook him up on home incarceration, and the staff lawyer says it'll be 6 months from that hookup.
Okay.
Okay. Thank you very much. And I'll try to get you hooked up, Mr. Hendrick. What are the court costs in this case? $310 court costs. I'm gonna allow you to pay that at $30 a month. starting 30 days from today to get you a chance to get back on your feet, okay?
Okay.
Okay, thank you. Who else is there next?
Jared Lawson.
Lawson, are you saying?
Yes.
Jerry. I don't have it either.
Not on the docket. What kind of case does he have? See?
Supposed to be final sentencing today.
Yeah, you waived final sentencing because you're a state inmate and we entered the judgment that day.
Still ain't showed up on my time sheet for nothing.
Well, it's a mistake somebody's made and we'll correct that today. Thank you for bringing it to our attention, okay?
Yeah, it's still a pending case.
Well, it won't be after today because you waived, okay? Thank you for bringing it to our attention. Okay, next.
James Forrest.
Ford. Commonwealth versus James Eric Forrest, 20 CR 0011. This is a motion for release of medical records. Is that right?
Yes, Your Honor. They may be relevant information in Miss Tooley's home health records as to whether or not she suffered any injuries prior to this alleged murder, and we're asking for those records. I don't think there's an objection from Mr. Gary.
No objection.
Okay, I'll submit the order and I'll sign it. Thank you
And
very
that's
much.
on Miss Tooley, and she's there also. That's the same motion on her and Mr. Ford.
And Miss Tooley I'll sign the order on Miss Tooley and she can be taken back into the cell block then. Is that Joanne Tooley? Yes. Okay, who's next?
Lucio Beltran Torres.
I couldn't hear you, sir.
Lucio Beltran Torres.
Beltran Torres. I'm looking at who from this. Yeah, we got a plate, looks like.
Commonwealth versus Lucid Bell Torres. 21 CR 0035. We're here today on a pretrial conference. You have a plea in this?
We've prepared paperwork, Your Honor. I don't know if it's been executed. I need to rest it.
What do you have here?
There.
Your Honor, I'm continue this for a.
You need to speak up a little bit.
As well as a pre-trial conference if possible. I know it's indicated that Mr. Austin.
You need to speak up a little bit.
I'm sorry.
Can't hear you. Speak up a little bit.
Oh, I apologize, Your Honor. I would move the court to continue this to a negotiation conference on October 1st and a pretrial conference on October 21st to give Mr. Austin an opportunity to go meet with Mr. Torres.
Well, if he can't do that, are you going to meet with him? Here's the problem I got.
Okay.
I appreciate the COVID situation, but I don't know how long he's going to be in that situation. These individuals that want to enter pleas, there's no reason for them not to be put on their way and if they want to and release Monroe County from the obligation. So I want somebody to prepare him and be ready for October the 1st negotiation and October the 21st plea. And if his previous counsel can't do that, then y'all gonna have to provide somebody else, okay?
I know that I won't be here on October 1st, Your Honor, but I don't mind taking the plea down to the jail to go over with them.
Well, you could say you don't want to be here on October 1st. You don't know for sure whether you're going to be. Are you going to be called?
Well, I physically won't be here because I'll be off on vacation on October.
Well, you
1st
hope to be off on October 1st. You want to try me and see if I can get you here on October 1st?
I would prefer not to be here on October 1st.
I like you because you apologize all day long. There's not very many people as nice as you are. So you understand what I'm saying, though. You know, somebody, okay.
And Your Honor, I don't mind taking him the offer and going over with his bill if I can sign it and get everything entered.
Well, if we can do that, Mr. Stockton, we might even take him up at another location.
That's
You know.
fine with me. We can even set a special day if they've got some they need to enter. I don't care. To do that.
Yeah, okay. Well, we'll try. You work with Commonwealth Attorney's Office on that. Okay, thank you. Who's next? Who's next?
Terry Jackson. Terry Jackson.
Perry Jackson. Commonwealth versus Terry Jackson. 21 CR 0065. And 18 CR 00158. What do we have here, Mr. Stockton?
Well, we have a plea to enter in 21 CR 65. He was voted into drug court this morning. So that will take care of the 18 case. I withdraw my motion once he's entered his plea on 21 CR 65.
Okay.
If they're ready to go.
I got assessed yesterday for drug court. So,
Yeah, and you were voted in this morning.
okay, yeah, and they said I will start Wednesday, next Wednesday, when he said I would start.
We're going to take a plea now.
Yes, Your Honor.
Okay, a motion's been tendered, sir, that you entered a plea in order to get ready for drug court. Is that correct? Are you currently under the influence of drugs or alcohol?
No, sir, I'm not.
Is this plea freely and voluntarily given?
Yes, sir.
State your full name and year of birth, and last 4 digits of your social security number.
Terry Wayne Jackson, 9/13/1983 and 8499.
Is your judgment impaired today in any way?
No.
Have you discussed these charges with your attorney? Are you fully aware of the information the Commonwealth has concerning your case?
Yes, sir. Yes.
Understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, you need to acknowledge those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at your jury trial, a right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendations, but I may apply any range of sentence provided by law. I do not have to accept it. Prior to accepting your recommendations, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the recommendations and decide to impose a harsher sentence, you have the right to withdraw your plea. Mr. Stockton, what is the Commonwealth's recommendation?
Your Honor, Mr. Jackson will plead guilty in 21 CR 65 to failure to maintain insurance, a $500 fine. He will also plead guilty to possession of controlled substance, first degree, receive a sentence of 3 years, probated for 5 years. The 3-year sentence shall run consecutively to indictment number 18 CR 58. He'll receive credit for time served. He must enter and complete the Monroe County Specialty Court. He'll pay court costs at discretion of the court, obtain and maintain gainful employment, and all evidence in this case be destroyed. I will say this, Your Honor. I've got an email confirmation that from Mr. Austin, he's supposed to go into drug court. It was inadvertently left off the plea papers. And I'll ask before his final sentence that we'll do an amended plea paper showing that drug court is included in his plea.
Mr. Jackson, did you include agreeing to go to drug court in your plea?
Yes, I agree to go to drug court. sir.
Okay. Now, you understand that after you enter this plea, you'll be a convicted felon. If you have any other felony convictions, they could be enhanced in the persistent felony offender law. Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Knowing your constitutional rights, so explains it still your desire to give up these rights, enter a plea of guilty and allow the court to fix your punishment in the range that permitted by law. Did you sign that document?
Yes, sir, I signed the plea, yeah.
I will accept the agreement, order a pre-sentence investigation report done and have you scheduled for sentencing on the 21st. Now, when will he be ready to go into drug court?
I think next Wednesday is what Mr. Meeks said.
So he could start drug court next Wednesday?
Well, the problem is, I don't know if they'll start him until he's final sentenced or not because of these rules from Frankfurt.
Okay, well, that's what I was wondering about. So what we'll do is we'll schedule him to sentence him on the 21st. And then he can start drug court shortly thereafter, okay? Okay, thank you very much. Who's next? It's a big room they've got there. Is there anyone else left? There you go. State your name, please.
Jesse Turner.
Jesse Turner.
Is this case
Commonwealth
set for trial?
Kentucky versus Jesse Dwayne Turner Jr., 20 CR 0003. Has this been set for trial?
It has not. I think it was previously before I got into the case, but it is not set for trial.
What do we have, Mr. Stockton?
We can set it for trial anytime, Your Honor. Mr. Bates called me about a matter. I will tell Mr. Bates that I have the cabinet looking into that for him, and I'll get him a response as soon as possible. And
is that on another case?
It's on this case.
This case
about a possible something else. But I should get a response within the next week. So if we want to set a trial date, we can. We're not making much progress on this case.
Okay.
Judge, I'll say this, I think we do have some motions outstanding. In addition, I attempted to file an ex parte motion with Your Honor. I do have copies of it today. It's something that needs to be taken up relatively soon.
We'll take it up today at the end of the docket if you'll stay around. And what motions do we have that are unresolved?
We do have one on the competency of children.
I'm having trouble here.
You need to speak up.
I believe there's one on the competency of children council. There were several by previous council that were never.
So there's a motion about the competency of the children as witnesses that is unresolved. And what are the other motions?
Judge, I'm not sure.
Well, I tell you what we'll do is you go through those motions and we'll schedule a hearing on those motions on the 21st. Just pick the ones you won't heard again and renotice them. And anything you don't renotice, we'll deal as withdrawn, okay?
That's fine.
And then if you don't have anything else that day, on the 21st, we'll schedule up in the day sometime so you won't have to sit through the entire docket, okay? Okay, thank you very much.
And Judge, did you want me to stay?
Yeah, we can stay if I'm sure that whatever it is, you'll need to get it underway. So I'll hear that when we finish the docket. It shouldn't be too late, maybe an hour and a half or something from now, okay? Okay, who's next?
That's all we have, Your Honor.
Well, thank you for your cooperation. Is nobody else there at all?
No, sir.
Wait.
He would have had Trey Williams, but he is in custody in Bowling Green.
Yeah.
And he's on the docket, and so.
He's not on the docket.
He's not on the docket?
No.
Okay, so that's what
Danny Pittman was supposed to be.
Danny Pippin's on the docket.
Danny Pippin?
I don't have him in here. I can get him if you need him.
Yeah, if you do that, it'd be great.
Someone to bring Danny Pippin to the courtroom.
Sure.
You called the state probation.
Announce the case. What's your name?
Actually, Harvey, Your Honor.
Okay.
We called the state probation officer. She made contact with them, tried to leave her officer voicemail box was full. I don't know what to do.
I guess I'm gonna go back in there.
Coming back, Mr. Stockton?
Yeah, I'm coming back.
Yeah, they're right here. Also,
There's samples from back there, and they're still there.
I can't, what's the main problem we have with this lady here?
I don't know that we've got one now. It's got our liability. The problem was. Like they mentioned in Tennessee, she served. Yeah. I don't really want to vote.
Be on your way rejoicing. But I don't want to see you back up here again unless it's a watermelon festival. You understand what I'm saying? Which, if I were you, I wouldn't attend. Okay, and you'll wait. I guess Chase, if there's anything else happens, they'll contact you. Okay. See you. Okay, take it easily. Okay, now Danny Pippin.
Sorry, Your Honor.
Now, in order to tell everybody there at the jail, we have some other people that are on our list that y'all have, and we're trying to combine. Shannon Clarkson also.
Yes, he's right behind me, sir.
Okay. Commonwealth versus Danny Pippin. 21 CR 0046. What's the story on Danny Pippin here? October the 1st, and the next court date is October 21st. Mr. Pippin, they say that your attorney and the Commonwealth are going to confer and are trying to work through some issues for you, okay? Pardon?
I have no chance of going home today then.
We would ask for, the reason Mr. Pippin was locked up, he came over and for members. Now, Your Honor requested that. You understand? He was there. He had, he's been in jail somewhere between 10 and 14 days. I can't remember.
I've been, can I speak, Your Honor?
Sure.
I've been in jail 28 days today.
28 days.
What were you dirty with, Mr. Pippin?
Your Honor, I was actually dirty on meth and marijuana. You have given me time to get my head clear, and I can keep my mind right. Give me a chance to go home to my family, Your Honor.
You want to put an ankle bracelet on him? I'll put an ankle bracelet on you. Okay. Put an ankle and have random drug tests ordered. Where they give you. I'm reinstating the bond. I'm reinstating your bond. Okay.
Your Honor, what about the money to pay for the ankle bracelet? I do not have right now. I do not have a physical address. I've got a place in Allen County I just bought. I have not got the address on it yet.
Okay, I'll let the Commonwealth attorney and your defense attorney reach an agreement when you get everything sorted out a little bit more. So I'm gonna leave you there. Do you get everything? Do you get a permanent address, make arrangements, get the bracelet on? And if they can reach some agreement before then, they'll send me an order, okay?
You talking about today, Your Honor?
I know I'm not talking about today.
What I was, I can pay for the ankle monitor, but I'll have to get out to get my access today. I mean, I can't.
Well, I mean, you need to have somebody to help you do that because, and I'll do it by agreed order. If you can contact your attorney, give him the details, he'll contact the Commonwealth, they'll forward an order to me. It could be tomorrow, it could be Monday, but they can't do it today because we're swamped, okay? Okay, thank you very much.
You know, specifically before, I've got 20 in from Brian Warren. I've only got one case left, William Rich. I've got documentation that shows that he was quarantined now.
Well, where's he at? Well, I know we had him in on the docket. He wasn't on the live docket.
It's a motion to revoke. I think there's a warrant for it.
He is, we're not through the live docket anyway.
But I thought there wasn't anybody else left here, so I.
But we still probably have 30 defendants left to call.
Well, they didn't show up. We'll have to call them.
Remember that. I'll just say reschedule this.
That's just to pay you back for your expert translation. That sounds like something that you practice in Cabo or something. I don't know. I had searched, there was an accent there.
I got the accent, that's what I gotta say.
Yeah. Rich, was that William Rich? William Rich is continued to October 31st. Okay, you too, yeah, too late. October 21st. Okay, now, who we got?
Shannon Clarkson.
Shannon Clarkson.
Yes, Your Honor.
Okay. I don't see. I don't see that here. I folded him up inadvertently with somebody else here. Commonwealth versus Shannon G. Clarkson, 14 CR 0074. You're Shannon Clarkson.
Yes, Your Honor.
Okay, we're here on today on a motion to revoke probation. Hey, what do you have? Wait a second, Mr. Clarkson. What's the Commonwealth have? You need to come over behind the microphone.
We filed another motion to revoke because Mr. Clarkson.
Need to speak up a little bit, please.
Yeah, we filed another motion to revoke on Mr. Clarkson. It was filed on August the 16th, except for today. And the problem has been is Mr. Clarkson's continued use of marijuana, meth, alcohol, and he still owes $14,855 in restitution. We've got 5,000 of it levied at the Department of Unemployment Insurance that we've not got yet. But he's not working, he continues to use drugs and alcohol. Other than that,
I'm obviously not prepared for a full blown hearing today, as I've not had an opportunity. Mr. Clarkson, I would move the court to continue the revocation hearing until October 23rd.
Do we have a pen in on him?
I'm not sure, Your Honor. Hopefully.
We'll put a pin in on him and schedule it for October 21st. And if you're not going to represent him, you need to get counsel for him.
I'm sorry.
Are you going to be here on the 21st?
I normally do not handle Monroe County, but.
Well, I understand you're here today. They're evidence that because you're so nice, you've been apologizing to me. None of these people ever apologize to me about anything. So you're welcome to come here anytime. And generally, but I'm more concerned right now about October 21st. So who's going to be here on October 21st?
Someone from my office will be here. on the
Okay, we'll make sure they talk to this gentleman beforehand.
I will
Okay.
make sure that's done.
You're scheduled for October 21st. Yes, Mr. Clarkson, you raised your hand so politely. What would you like?
Chase had me assessed for life skills places, and I've got 50, they agreed to do, let me do that. And I'm willing to do anything I need to do to be out of jail. But I was willing to pay $1,000 a month, starting next Friday. If you would.
Well, here's a problem, Mr. Clarkson, we have here.
I'll just start.
Wait just a second. Here's the problem. The guy stole my dog and promised me he was going to bring it back. Okay. Anybody that'll steal your dog might not bring it back when they say so. Okay. So I know you're well intended, but there's going to have to be a little level of confidence that you have to rebuild with the Commonwealth before we get there. So you can have your attorney call the Commonwealth, and if y'all can reach some arrangement, I'll be glad to consider it. Okay. If not, you'll be back here on October 21st. So if I were you, I'd be working towards some arrangements to make restitution and take care of these other problems. And you obviously need drug treatment, because unless you want to go to the penitentiary. Okay, thank you. Now, who else we have in Glasgow? That should be it, Glasgow. Thank you so much for your patience. Russell County Detention. Who we have there? Russell County Detention. Carrie Johnson, Russell County Detention.
Yep, I can't get the video started.
Well, I got to they assessed me for last year. Why? I said, the way I get confused. I do too.
There you are, Carrie Johnson. Commonwealth versus Carrie Johnson. Okay, is this a Monroe County case?
I'm actually somewhat familiar with Ms. Johnson because I represent her out in that Cass circuit. She does have another case that's also pending. I think it's scheduled at the end of October on that case. I know that would be pretty consistent with what the Commonwealth has offered here. I think we're trying to figure out what Russell County is going to do. What I would request them to do, that means, yeah, I don't represent her in Russell County. She actually has a conflict counsel. I think I was representing her. What I would ask the court to do is to schedule for a pre-trial conference.
What about transferring this case to Metcalfe County, the judicial economy?
3 different Commonwealth attorney circuits. 57th, the 40th, and John Gardner make that up. So we can transfer 2 to make progress.
Well, transferring one would make progress for
Make
you.
progress, but I mean, if we can just set it for the 21st.
Let's set it for the 21st and see if you can't get some cooperation to put all these in one
I'd
jurisdiction.
be glad to transfer this.
See right there, you already hadn't even got started. You got one volunteer already.
I have been working pretty.
Okay.
Problem has been in Russell County where.
Okay, October 21st.
I'm not sure if it's gonna be finalized by October 21st.
Okay, well, if it's not, we can continue. If you can't get it wrapped up, we can continue. Thank you. Do we have anybody else at Russell County? Thank you for cooperation as always, okay?
Thank you.
Okay, now let's go through the rest of the docket here real quickly. The live.
Yeah, it doesn't look like Pike County and Simpson County joined us.
Yeah, Pike County, it's dinner time up there already. On that fast time. Casey Newton Bostic.
I received an email from Mr. Baker, the attorney yesterday, asking to continue for mine. I said, please send me a agreed order that was supposed to be in quarantine, and I never got the. That was what happened. One case again.
Who is the attorney?
Matthew Baker.
Well, issue a bench warrant. And you can, if you call him out, you can send me an agreed order before it's served. James Warren Bostic. Do the same thing, bench warrant, subject to recall on agreed order for the attorney. Reason I did this in Clinton County the other day, and I'm doing it again today, because I have to have some certainty that these people are communicated with in writing to make sure they know when. That's right. That's right. Crystal Gail Botts.
My apologies, Your Honor. Ms. Botts was in contact with our office this morning. She was showing signs and symptoms of COVID and was going to get tested. And she is supposed to be emailing that proof to me as soon as she gets that done.
Okay, well, I will issue a bench warrant for her appearance unless there's proof given within 24 hours of a positive test. Okay? Thank you very much. Jonathan Bridges. Jonathan Bridges. Anybody know anything about Jonathan Bridges? Okay. It's your bench warrant. Is the next thing on the docket Brittany Carnes? Could you get somebody to call Pike County while we go through the rest of this, maybe?
Yeah. Pike County Detention Center. Okay, you gotta keep our callers.
Lana Carol Cross. Lana Carol Cross. You want to get behind the microphone here? Issue a bench warrant for Lana Carol Cross.
For Ms. Cross, I do have in hand a medical record dated 9/6, which indicates she's positive for COVID-19.
Take a look at that, Mr. Commonwealth Attorney.
Just said it for the 1st and the 21st.
The 1st of October for negotiation and the 21st for entry here. If she does have the COVID, she'll need a better document than that. That's a little weak. I want a doctor's statement attached to that. And if I want a copy of that file in the court record, and if she's presented a false document, you'll know where to find her for the next 6 months or so. Let's give a copy of that. Erica Decker. Erica Decker. Anybody know? Bench warrant on Erica Decker. Jared Ford. Jared Ford.
That was the other day that I couldn't get on.
Okay, could you have somebody take a look at Simpson County while we're still here?
I need that case has been in a while and they were going to look through about discovery and get back with the negotiation.
Was October 1st too soon? Who represents Jared Ford? October 1st and the next order is 21st. Tony Graves.
It looks like those cases need to be made.
I'll probably need him here before I can do, I'll probably need some explanation of that.
Next to the one where he's on parole and trying to post the DUI. We could try to get done by that. It's gonna have to be tried.
Well, he's charged with PFO, so.
Yep.
Well, no, he needs to be here and y'all just need to be, I just want something in the record, protect you and everything. He needs to be here just to protect everybody. You know what I mean? Ashley Hart, did we already? Sounds like a name from Heart of Dixie or something. Jesus Padilla.
Yeah, I did not proof from his court today. And I guess I need to work to continue the hearing to give us an opportunity.
Jesus Padilla.
That's we filed a motion to revoke bond because he was violating the terms of his home incarceration. And he had a pretrial today, so I think he's confirmed our motion.
Issue a bench warrant without. Somebody. Yes, somebody say something there.
No, that's Pike County.
Oh, Pike County, what's that case?
Yeah, I apologize, Judge. We're running another court at the same time.
No problem, man.
Brittany Corn.
Brittany Carnes, Commonwealth versus Brittany Carnes, okay?
I've got it right here, Your Honor.
Okay, thank you. Commonwealth versus Brittany Carnes, 21 CR 0085. Are you Brittany Carnes?
Yes, sir.
Okay, we're here today on an arraignment. Brittany Carnes.
I thought I signed, like when I took that 2 years, that all these charges was dropped.
Let me arraign you first and we'll talk about that, okay?
Okay.
The grand jury of Monroe County has returned an indictment charging you with theft, unlawful taking, and being a persistent felony offender. Are you Brittany Carnes?
Yes, sir.
Okay, I'm going to sign a reciprocal discovery order and your attorney here can look into that for you. What is it? Did you hear what she just said, Mr.? They said they would review that for you. Are you going to be there for a while, the next couple, 3 months? How long have you got there?
I go for pro in November.
Okay, well, I tell you what I'm going to do. I'm going to set it on October 21st and your attorney will get an opportunity to review that, but will you acknowledge her identity?
Yes, Your Honor.
And waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions. And what I'll do is we'll review that. And if we can get an agreed order that will take care of this for you, you'll be receiving it. If you don't, you'll be back in front of us on October 21st by Zoom. Okay?
Okay. Thank you.
Thank you very much. Thank you, Pike County, for your cooperation. Y'all have a nice day. Okay, now let's go down to, we did Danny Pippin, didn't we?
Yes.
Yeah, there's another charge of his that I didn't pick up. Vernon Pugh.
I'm here, Your Honor.
Okay, there.
I'm here, Your Honor.
Okay, Vernon, and who's Mr.
Judge,
Wilk?
thank you.
Yeah.
I'm pulling
There
over.
you-
Thank you, Judge. I'm here as well, Mr. Pugh.
Okay, we're a pretrial conference here.
Misdemeanor plea, he has paid the restitution full, but just be 12 months probate for 2 years. No violation of law.
Okay, Mr. Pugh, I understand that you have filed a motion to enter a misdemeanor plea. Is that correct?
Yes, Your Honor.
Okay, you have your constitutional rights. What will the plea be to? Well, here's what the offer is.
He's definitely off the table under 500, but he's paid over $5,000 for restitution.
So it's theft by unlawful take under $500. So it's not an enhanceable charge or anything. You have certain rights that I have to read you anyway. You have right not to testify against yourself. No one to make you say anything. Right to speak trial by jury. Right to be represented by counsel, jury trial. Right to confront and cross-examine all witnesses called testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt. Now, I'm going to, on a misdemeanor plea, he just told you what it was there. Is that what you agreed to?
Yes, Your Honor.
Okay, well, I'm going to go ahead. And you feel like you've been adequately represented by counsel. You appreciate and agree with the advice and say that you're satisfied with the advice your attorney gave you?
I am, Your Honor.
Okay, I'll go ahead and sign the misdemeanor judgment. And Mr. Wilcutt, is there anything else you want to go over before I enter the misdemeanor judgment?
No, sir. Thank you.
Okay, thank you all very much. Have a nice day.
Thank you, Judge.
Yeah.
Will there be, Judge, will there be any other fees I owe to the court or anything, or
Court
is that
costs,
everything?
what are the court costs here? It'll be in the judgment, but let me just tell you what they are.
Because I paid a little more than what the restitution was. There was some other charge in there
Yeah.
besides the restitution.
Let me find out. It'll be $215 total court costs and everything.
I'll take care of that today.
Okay, thank you so much. Have a great day.
Thank you.
Cromwell versus Stephen Reed. We did call that case earlier. Okay. Yeah, that was James K. Scott. Okay, get forward. Ronnie Vincent.
Judge, that's my client, conflict counsel. I've got notice that Mr. Vincent has reported that he is sick today. He left that message with the DPA office and they forwarded it to
Well,
me.
he and 50 million other people are sick, but I'm gonna give him 24 hours to show some kind of doctor's report on COVID or something like that. You know, he's got to get, I'll give 24 hours for him to get a doctor's statement. If not, I'll do a bench warrant on him. Okay.
All right. Thank you, Judge.
Very much. Now, is there anybody else on the docket? We had one Simpson County case, didn't we?
Was that Richie Lawson?
No, Richie Lawson is in the Dare County. Okay, does that conclude the criminal docket? Okay, we're going to take a short break right now. Okay, that was the break. So we got the child support docket. Are y'all finished today? You've got something, yes.
We're gonna talk to Mr. Bates.
Yeah, you want to come up? And we'll do this in our short break here. I'll put the bench conference thing on so nobody else can. Yeah, you have it.
And I don't know if you got a copy of my
Let
motion.
me just have it here. Okay, we have a bench conference on. This is an ex parte motion here in the case of Commonwealth versus Jesse Turner. You want to review the Barron River Area Child Advocacy Center recordings. Is that correct?
That's correct, Judge. It's not an agreed
Hold
order.
it down just a little bit. Somebody, just hold it down just a little bit so nobody but me can hear you. Is this usual? I mean, you understand the sensitivity of these things. So you're just going to review them yourself. You're not going to make them available to your client or what?
Well, here's what, I already have the recording. We had signed an agreed order. Mr. Stockton was good enough to sign an agreed order so that I could receive those. I've reviewed them, but I would like a psychiatrist to review them, and I'd also like to make transcripts. Of course, would mean a third party would have to review different third parties. Obviously, I'm asking for permission. I did not bring it up to Mr. Stockton in specific, because obviously that starts tipping off our defense. And that's one of the.
Well, you know, I'm not much of a tipper off her defense. You know, we have a discovery here that works pretty well. What would it tip off to me?
Well, you just need to know that I'm sending it out to get reviewed by a psychiatrist. And in
Well,
theory,
if you have a review by a psychiatrist and you get an expert opinion, you've got to disclose that to him.
I understand if I get an expert opinion. That's correct. The biggest concern was the agreed order.
Let me just read this. Okay. I want you to put out the select third parties by name that you select third parties is a too general a term. So what you're going to do is if you're going to use name a psychiatrist.
I can name the expert and I can also name the transcriptionist.
Okay, that'll be fine. You do that. And I'll sign it. And also put some language in there that they should keep the evidence confidential.
I'll do an NDA with them.
Okay, thank you very much. Just send it to me.
Judge, how should I send that order? Should I just email it?
Yeah. Megan, how would you, he's got an ex parte order. He wants us to email it to you.
Yeah, did you email it to your, attached with your motion? I know you said.
I did, but judge wants me
Okay,
to.
yeah, you can just email it to me, that'll be fine.
Okay. I will go ahead.
Megan at.
It's all, yeah, maybe comes in a pay like it, so.
Okay. Thank you very much. Yes.
Mr. Carter wants special treatment.
We have it.
Grand jury's got a kid sick in school in Albany, they got none, so I don't know if them up here.
Let me just go down there and I'll do it. Okay.
Carter wants his wife all of that. Yeah, it's going on election year.
Concentrate on the look at horses and weddings.
Buddy, I ain't seen her in a long time.
She's got some Jerry. Down there here today, when she goes to work at school at night.
Maybe she was doing that.
She drives like that. Beep. Oh, gosh, there's stuff. When she's like.
That's all.
Be frank, I want to ask her what she wants to be called. She'll talk about it.
She won't?
We're gonna call her Granny then.
Mammy. How old is she?
53, 54 maybe. No, we're 50 because she's right 50 and over state. She's done that for at least 2 years, maybe 3.
You're still turning barrel.
And this week, when I was at church, so I had to get Sierra's horse and I've never ridden it. So I rode Monday, Tuesday. Lay off on the day and then take her to the show. See what we do. Maybe a train wreck.
Where's that at?
On the Liberty, Kentucky, up there where the Target Gate Company and all that.
They got the big thing.
Yeah. Fairground over there. The road a lot.
Yeah. Except back when I still worked, they sent me, I don't remember, some big bill sent me the prints on that thing. on price and putting that.
Overly far away. And the little town's building up. Every time I go, they got a new restaurant.
Really?
Taco Bell or Sonic. Lee Sam's Recipe, McDonald's and pizza now.
I can remember back. It would have been late 60s or 70s. It was like going through mud big.
Yeah. First time I went up there, they like they had a McDonald's.
They didn't have that either.
It's little, it's not for a family. Little though.
And Target was.
Huge.
Well, not
Oh,
then,
wasn't it there?
no, it was there, but you know, they,
Little buildings, but
yeah,
it
dirt
just
floor.
makes it scary whenever he goes through there. You can't watch the road. It's like, I need to come up here and get some, something about the city, they fill up there certain days of the week or something.
I knew a guy that was, okay, he said his nephew lived that person where he would bring a truck and load it with gates, start across the country, so. One at a time. Probably give that 14. child support.
This is Maddie Denton. She is Monroe County Child Support.
Oh, Maddie Denton from the Monroe County Child Support. Well,
We changed a lot since the last time we were here. Full-time employee of Monroe County Child Support.
really?
Yeah. Casey went to work for the state child support. Barbara, my place.
How long did she work there?
Since 90.
Since you were a mere child?
Yeah. She worked.
Mississippi?
She worked for the Carters.
Yeah, that's right. I remember that. Which you start with Edwin O. Arms Jr.
Yeah.
So a testimony about to give us the truth, whole truth, nothing but the truth. Okay.
State your name for the record. You're employed with the Monroe County Child Support Office. You're familiar with the case of Lydia Arms versus Evelyn. Your arms have been raised $6,035.89. Yes. He is an able-bodied person capable. Judge, we've asked for an order of contempt and purge.
Okay.
$6,035.89. Brown.
Is this Edwin Arms here? Is he a Monroe County person or a Cumberland County person? Yeah, there's Edwin Arms over there. Don Lee Barber versus Farron David Barber.
We have an order establishing child support, which is child support guidelines. It is $381.57 per month. Child support
Okay.
payments.
Fox versus Fox.
Review this October 21st.
Gallup versus Gallup.
Review October 21st.
Heston versus Heston.
Review October 21st.
Hudson versus Hudson.
This is 17 CI 50.
Right.
You're still under it. You are familiar with the case of Richie Hudson versus Angela Hudson. And Miss Hudson has $3,627. Or here where she's an able person capable of providing support. As we ask you to judge your rear that figure, or in contempt, allow it to purge.
Now, we had a person that came online that's in the Barron County Jail earlier today, and I don't remember his name.
Ansel Williams.
Ansel Williams, and he had like $6,000 or something like that. Well, that's what the order said. I guess you just gave him a partial to purge, right? Okay. Okay, that's what I was going to ask, is a partial. I think Ansel said if I let him out, But he the one that said if I let him out, he'd pay $1,000 a month starting next month. But he the one that said that.
He wasn't on our docket, he just came on it.
He just got in the group. It's like 1,000 people and they walked from downstairs up. He just kind of slid in there. Valerie Hudson versus Richie Hudson.
And this is O2CI 120, we have two Hudsons, that's why I verified.
Yes.
This one we actually did October 21st.
Eisenberg versus Eisenberg.
This is O1CI 68, it has to review it Thursday, October 21st. You're on, it's the next day. You can come on. This is another item.
Okay, this is Christopher Eisenberg versus Heather Farrell. Eisenberg 12 CI 0052. Hello. Blessed, thank you.
Heather, $4,234.24.
A lot's happened since since I was making payments, a lot's happened, and I'm going to, I've actually helpless at one point. And I've had a lot of health problems. I signed up for school to go back to college as well. And there was the medical issue to the COVID. And then after that, I relocated to here to Monroe. And my children are with me pretty much 80% of the time.
Well, here's the thing about it. I cannot modify the order here. You'll have to get an attorney and go into the civil court and make a motion to reduce or ameliorate that in some way. The county attorney's office and the child support selection section of that is responsible for enforcing existing court orders.
Okay.
And they can modify an order somewhat unless it's under a court, like if they establish child support or whatever, you could go for a change, but they don't have the capacity, as I understand it, to do that. So I'll go ahead and sign this order. What is the order?
She has already $4,234.24, and a lump sum payment of
Wait a second.
$500 on October 21st.
Okay, okay, so what you do is you have to make a $500 payment by October 21st. Now, the rest of it, you could challenge the amount or you could try to get a reduction or whatever, because we don't come back to court here till October 21st. So if you want to get an attorney and challenge any of the rest of it, but you'll need to pay the $500, you'll be in contempt. Well, you need to present that to the Commonwealth Attorney, to the county attorney's office. But if she's under an order, is that she's not paying under y'all's calculation, she's paying under an order, right? See, it's different. So you'll have to come back. You might come back in front of me, but it won't be in this venue. It'll be on the civil docket. So you need to get an attorney. But right now, you can purge yourself of contempt by paying the $500 by October 21st, or there'll be 60 days in jail. Okay.
Okay, so do I just pay that to the
Clerk's office or,
Child support, ever how you normally pay your child support.
yeah.
Or you can make the payment.
Okay, because I was bringing it in.
Okay.
Frankfurt.
Okay. I think I'd take it to the county attorney's office if I were you. Okay, just this one payment. Yeah. Okay, thank you very much. You give it to you get an attorney, you give it to them. He cannot modify that. He cannot modify a child support order. Okay. Okay, thank you. Joiner versus Joiner.
Mr. Judge, you're still under, if you're familiar with the case of Terry John versus Kenneth Joyner. Kenneth Joyner has $15,400.59 as of yesterday. And as far as you're aware, you make quite a person capable of fighting for it. This is a rear government. And we ask you, the judge's rear is $14,459, pay $1,000, purge yourself of contempt.
Manley versus Manley.
You're still under, remember, Tabitha Davis versus James Manley, 14, 28. $7,250 as of yesterday. Or here where it's had the lowest person making this payment. This is also an arrears only payment. Council I purged on $500 lump sum payment October 21st.
Pruitt versus Pruitt.
And you're still under a disciplinary case of Pruitt, Pruitt 19, plea 49, is that correct? Yes. Pruitt, it's 3,000.
Is it here? Are you Jessica Pruitt? Come on up here. Christopher Pruitt versus Jessica Pruitt.
This is Miss Jessica Pruitt. She is in agreement that she has arrears $3,777. That you would actually only can't allow her to purge herself from making a lump sum payment of $500.
Okay. So understand you have to make that payment. You have to make that.
456 East 4th Street. Yes. I'll make sure you get a copy. That's where they'll mail the copy.
Okay. Yeah. Reagan versus Reagan.
You October 21st.
Okay. Good job. Okay, what time's the civil docket start at 2? Yeah. Janet Blair, Mid-South Capital Partners versus Janet Blair. Wes Stevens. Mid-South Capital Partners versus Janet Blair and others. Is there an order? Check to see if there's an order in there. Just put it in the stack to sign, okay? Heather Lynn Branham versus David Shane Branham. Now, are you Heather Lynn Branham and you are David Shane Branham? Okay, what do you have here?
Your Honor, we filed a motion to enforce. There was a separation agreement signed in November of last year, it appears, and it was filed November 16th, 2020, I think adopted by a final decree January of this year. That gave the parties joint custody, named Heather Lynn Branham as primary residential parent, with David Shane Branham having visitation according to the model home care guidelines. However, Ms. Branham is arguing that Mr. Branham has not allowed her visits in several months with the child. And we're just asking the order be enforced as it's written. Is that correct?
Well, let me see what he has to say. We'll see if we have to take some testimony. You kind of step forward a little bit there, just a little bit. Okay. What do you have to say in response to this?
3 years ago. She's been enrolled in school. It's under my name. She's lived in my house for the last pretty much a whole life. And now, just because she's got somebody paying her mortgage,
your nose.
And that's not only, like, I said, you can talk to her by herself, and she'll tell you. And she'll tell you why. And like I said, she's been in my house.
How, what is your name, young lady? How old are you? Well, do you want to have a hearing with the commissioner, or what do you want to do?
My client would like to see her child.
Well, the problem that you have is the child is 16. Do you not want to visit? Okay. Well, see, unfortunately, you don't get to make that decision yourself all the time. Okay, where you have to be put to a choice of choosing between your dad who's raised you and your mom who is alienated from you, but maybe want to start a relationship with you. So I don't think, I mean, the order is in place, and until it gets modified, they've got a right to enforce the order, whether or not she's complied with the other aspects of it or not. I don't think it will help anything to force the child at this juncture without some kind of counseling or something. You want to come back over? Well, let me tell you something. Well, I understand that you're trying to protect your child, but she's not going to, if she rebels against something that I say, she'll end up in juvie somewhere. She'll be taken into custody if she doesn't file an order of court. And I don't want to do that. What I want to do is to see if there can be some counseling done or something right now, because it's not a healthy relationship. And I really don't, I know that I accept what you say about taking all this. Well, wait just a second. Okay. I accept what you say about taking responsibility and raising a child, and that's commendable. But we've got to accept that no matter what anybody else has done, there's a possibility of forgiveness and redemption in life. We've all made mistakes. I don't know what this lady's done or hasn't done, but I will tell you one thing about it is if something happens to your mother and she got killed in a car wreck or something, sometime down the road, I think you would have some regrets that she didn't have a chance to apologize to you or talk to you or something like that. It's something that needs resolved for you. You know, you can't, adults don't always act right, and they don't always treat kids right. Okay, well, it's not your time to say anything yet. Okay. So I'm not going to force this child to visit her mother without any kind of counseling or anything. But I can order some counseling of some sort to find out, to let her talk about the problems that she has with her mother. I know that you're angry at the mother probably too, and disappointed probably be it's a better thing. But I think that down deep that you would have to acknowledge it would be better, even if she can't resume a normal relationship with her, even if she can't. It would be better if she talked it out and had somebody give an opportunity to have some resolution in it. So it's not an open book and an open sore. So have you ever had an attorney in this case? Yeah. Well, what you need is try to do something to have your daughter to have some kind of resolution to problems. It's bound to be a problem if you feel like your mother has deserted you and hadn't anything to do, it's a problem. It's a problem. I mean, we're all just human. It's a problem. So what, do you have a counselor or anything that you would recommend? Who usually does things?
Off the top of my head, I don't know. I was going to ask the court if you thought a guardian ad litem would be appropriate, or if you refer to the commissioner. I know we've sort of been out there before.
Well, I think that I can't appoint her a guardian ad litem because she's a minor and an attorney to protect her interests to do what she wants to do. You're her guardian in real life, her father and guardian, but I think a guardian ad litem, or you think a friend of the court or guardian ad litem would be better? Yeah. Ann, Gordon Anderson do that, or she's approved?
We would have.
Okay. There's an innocent person over there. Yeah. This is Mr. Coleman Hurt, who has just been appointed to represent you. He's from Barksville, and he got a practice in Russell Springs with former Speaker of the House Hoover. And I'm going to continue this to October the 21st and allow him to interview you and get your interest. And you can sit in on the meetings with her, you know. And at some juncture, he'll probably want to talk to her privately, though. Okay. So I'll just continue this to 21st. And if Mr. Hurt and Mr. Carter can work something out after they talk to everybody before then, to allow the parties, you know, the daughter and mother to talk somewhat. You probably haven't lived long enough to do anything very bad. You don't look like you've ever done anything very bad, you know, or maybe you haven't ever made very many mistakes, and I hope you never do, you know, but I've lived a long time and I've made a lot of mistakes, and I've had to ask people for forgiveness and receive it. And I've had people ask me for forgiveness. Now, sometimes it's harder to forgive somebody than it is to ask them forgiveness. You know what I mean? So maybe y'all can try to work on that with him. I'm not telling you to do anything, though. Okay, I'm not directing you to do anything that you don't feel like doing or anything except talk to your new lawyer. You'll go over there and give him the address, and if y'all reschedule this on the 21st, and Mr. Hurt and Mr. Carter, if y'all can, after you interview her, if you think it would be helpful, if the father and the mother and the child have some counseling to see what would be the best resolution for the child. I figure you've been around long enough, you can take care of yourself, but my goal is to take care of her. You know what I mean? And that's what your goal is. We share a goal. Okay, thank y'all very much. Yeah. Mitchell Russell versus Ashley Curtis.
Your Honor, Mr. Hart and I ironically are working on that case, and I think we're posting.
Okay, you want to renotice it, or?
I think we have an agreement.
Okay, are the parties here? Mitchell Russell and Ashley Curtis, are you here? Okay.
I was just getting ready to let you know. I have received 2 of them. So.
What mine usually says, how are you doing? And I know if they're not asking me about the warranty on my car, that somebody's hacking me. You know?
You were there arguing and I get a message asking for a favor.
Which wouldn't be too ironic.
Yeah. Okay, Mitchell Russell versus Ashley Curtis. Okay, what you got going on? Where's your client?
I'll get him to, she's in a waiting room.
Yeah.
What do you need?
Right.
Favors?
No, money.
No.
He said he needed money.
Yeah, I'm not buying that. No.
Ticket to Vegas.
You better get your money you want off him today. Okay. This is Mitchell Russell versus Ashley Curtis. Now, what do we have here?
Judge, we have an agreement that is by no means a final agreement between the parties, was to get us there so we can get in front of the BRC.
Yeah.
And the parties would agree to start off Mitchell Russell's visitation, which
There's one child involved?
one child.
Okay, now was this a knowledge paternity or a DNA paternity or what? DNA paternity, okay. And so is there any child support involved?
Your Honor, we're going to be seeking that. We'll have, hopefully get a final BRC here. child support at that point.
Well, the county, the child support, all,
For a temporary, we agree 300 per month.
okay, that's fine. Now, what are we gonna do about visitation?
Beginning next week,
How old is the child?
It's 3.5.
3.5.
Yes, Your Honor.
Okay.
Mr. Russell would have a 2-hour supervised visit at the cabinet for Health and Family Services. That would be next week and the week after. Long as all goes well, then a 4-hour unsupervised visit the following week, an 8-hour unsupervised visit the following week after that, a 16-hour visit the following week after that, and then again with the alternating weekends. We're hoping to get a hearing before this is.
It is it, what's the child's name?
Waylon.
Waylon? Waylon. I don't like to refer to somebody just as the child, you know what I mean? It's kind of impersonal. Does he know you?
He knows of him, Your Honor, but he's not been around him in almost 2 years, so
Yeah.
he's gonna be
Well,
very.
well, that's the reason he'll be there at the cabinet. We can see how he reacts. And of
Yes,
course,
Your Honor.
I want you to include a status quo order in there.
Yeah, we got it.
And what a status quo order is that the child is getting old enough now to know things. And I mean, it's actually amazing to me how much they do know and how much they pick up. So everybody needs to be very careful to leave any differences that y'all have had between you behind, and hope a lot of times if children are exposed to that too much, they're sentenced to repeat it in the future. You know what I mean? So that should be the goal, is that, well, you get to see your dad today, try to build him up about it instead of saying you got to go down to social services today and see, blah, blah, blah. It's hard to do sometimes, but maybe we can work it out. If y'all gonna submit, or both of y'all agree with this? Is that correct?
We also agree that exchanges, once we get past the cabinet visits, will take place at the custody exchange area at the Thompsonville Police Department.
Yeah.
And
I think that's everything.
Now, what about communication between the two parties? Should
Well-
it be by text?
is that agreeable?
That's fine, that's fine.
I think-
And we want to limit it to just related to the child.
Well, let me tell you, that's the best way you can do it, is do it by text. And that way there's no he said, she said, they said. So you ought to communicate. Now, we won't do anything at first, but after a while, it'll be necessary as the child gets older, and maybe you'll bring this up to Commissioner, to get some FaceTime or something like that with a child later on whoever. I'm sure at least at first you'll have trepidation and problems when the child's not with you and with your husband. And as you get more attached to Waylon, then you're going to want to just see him and encourage him and stuff like that when you don't have it. Okay, well, thank y'all for agreeing. And I hope it works out.
Thank you.
Yeah, Parker versus Parker. Renotice. Okay, that'll be fine. Wheeler versus Wheeler. That is a motion to put child in counseling and motion for contempt. Nicholas Carter's involved in this. Wes Stevens.
And Mr. Hampton and his client have executed an agreed order. My client is out of town.
Let's see it pass. So Whitaker versus Whitaker.
I had an agreed order executed by everyone.
Oh, that's great. Barnett versus White. Says renoticed.
Yes, Your Honor, this was the renotice, my exceptions I filed for. We were in front of the court, I believe 2 months ago. The court, I don't think ruled on it, sort of guided us to have some discussions and if we could settle this.
How's that going?
We sent a proposal, I got one about 3 weeks ago from Mr. Stevens for A little far apart, our proposal was basically that my client received 12 days out of every 28, which was kind of not the equal time share. The response was for my client to receive 10 days out of every 28.
How about 11? That's halfway in between the two offers. What about 11? Well, I'm wanting an agreement, but we'll have, as a commissioners heard this, and what did he grant?
He said no change from the previous order.
See, 11 days is pretty much of a lock. And think about it, if I rule and the court, they can take the case up to the Court of Appeals, and even if you win a ruling from me, you have no certainty till the Court of Appeals. They have a right to one appeal by right, take months, so.
Judge, the only thing I would say, this.
How
case-
many children are there?
Just one child.
How old?
Uh,
Yeah.
And Judge, this is a particular history. The court probably aware this case was in front of the commissioner years ago. The commissioner granted equal time sharing. This, Your Honor modified that. It was appealed up to the Supreme Court and then came back and we filed this motion modifying it, basically restarted with the commissioner. The big issue along the way has been lack of communication, problems between the parties. I think there was testimony to the ORC that would show that has improved. And my clients also.
So the commissioner did 50-50 and that.
Years ago.
Years ago, the
But
initial.
this, after this most recent, he said not to change.
That's correct.
Did I change the 50-50 originally?
You did.
What did I change it to?
I believe it was essentially standard time share, standard visitation.
Weekends.
Except for, no, what he changed it to is what it is now, which is every other weekend. Every other weekend, and then Wednesday and Thursday. Fall.
Pretty much what used to be the standard visitation.
With a little extra.
A little bit of CPR.
Judge, and yeah. This is a question of fact. The DRC has heard all this and applied the law to relevant fact. It's no longer a legal question, it's a factual question. My client didn't testify. How many days out of the last 3 days? It's like 40% of the time, because one of the issues we have is in the summer where you say 2-week period, he makes sure it's his weekend on the end of each one. And he takes 18 or 19 days. My home doesn't get to see the child at all. And I don't think that's in the spirit of, I think a 2-week period is not to make it almost 3 by saying, well, this is not weekend visitation. So that, and I say that, there is no negotiation.
I used to have a secretary that did that.
Yeah.
I mean, I wanted her to start taking her week's vacation on Wednesday, and she wanted to always start on Friday till a week, 2 weeks from Monday, and so I was closed down. But I can understand why everybody wants as much time with their child as they can.
Yeah, but Mr. Barnett, through the history of this case, and it's been a history of this case since the child was 2 or 3 months old, has always just reached and grabbed and manipulated instead of working in good faith. We've had him up for contempt multiple times where you told us, probably contempt, but I don't want to hold him in contempt, just do better, and then he finds a different way to manipulate. That's why we've set forth a good faith basis. We proposed that he would get every Tuesday, add 1 extra day each week, based from what you had ordered. So he's getting, it's only 5 nights, but that turns into 7 days. We've attempted a good faith negotiation. Now we think it should just be a ruling based on the facts in the law.
Judge Baker, respond just briefly. I don't think that this court or anybody should fault Mr. Barnett for wanting to take the most time with the child possible. And if this is, I agree, there are.
Well, let me stop you just a second. As I reflect upon this, we had the issue of whether there had been a sort of change in any kind of circumstance that would have brought this back in front of me. Wasn't that an issue at one time? So you're telling me that the commissioner ruled, I ruled, we took it up to the Court of Appeals, did the Supreme Court rule? Was it a reported case?
Court of Appeals.
Court of Appeals.
It's the published, as Judge Lovelace used to say, it's a similar case on whether or not.
They ruled against me again.
No,
They upheld here.
and Your Honor, I
It's a
think.
fine decision.
That was around the time that the presumption changed for initial.
I remember the case now because they talked about the presumption wasn't completely, you could have factors. where you could-
Whether or
not parties' ability to get along is a factor to overcome the 50-50.
Right.
Yeah.
Right, and they don't want to disturb the trial court's
Yeah.
findings.
But then since that we had the case by the Supreme Court that says 50-50 is only for initial determinations. It's no longer a presumption for a modification.
Yeah.
And that's right, and we discussed that the last time, and my argument for that is, if that is the case, which I would concede that the Supreme Court said that, then the commissioner applied the wrong standard because he applied the wrong statute.
Well, let me tell you something about standards and statutes and stuff. At some time, these two parties ought to be able to reach some kind of agreement. And I remember it's kind of some of it flooding back right now. And so you've offered 10 days. Is that what you offered?
That was my calculation, what it came out to. I have Mr. Stevens' letter on my phone. If I can read it.
Well, read it, see what it is.
Judge, I have the paper copy.
Oh, that.
We'll just read it out loud, see what it says.
John Barnett shall exercise visitation of the child as follows. Week 1, he receives the child at 6 p.m. and returns the child Friday at 6 p.m. Week 2, he receives the child Tuesday at 7 p.m. and returns the child Wednesday at 7 p.m. and then Friday at 6 p.m. till Sunday at 6 p.m.
That's my recollection of it, like I said.
Wednesday to Friday.
That equated to 10 days and
And
everything.
then Tuesday night, following week, and Friday or Sunday. The other.
Yeah, no, there was 1 day. Right. Right, it also had clause in there about summer visitation being released. Again, Your Honor, the parties have communicated better, and that's my understanding, according to what Mr. Barnett tells me, there have been issues, they've done doctor visits together. There was an issue, I think, where the respondent's grandmother maybe passed away, and they coordinated to make sure the child was there, and everything went well. Things have gone better with phone call communications with the child and between the parties. The other thing I would just say is the DRC's hearing on this was almost a year ago, and we're now having the exceptions heard.
Well, there's been a lot of stuff going on in the last year, Mr.
I'm saying,
Ramsey.
yes,
You know,
absolutely.
I bet people been dying by the thousands.
Absolutely.
We hadn't had any
The
court.
DRC heard all of their testimony. That
Yeah.
people were getting along better and everything, and he ruled not to change it. That
Yeah.
There are still significant problems with the relationship between Mr. Barnett and Miss now Branham that cause them not to be able to co-parent. It's not in the child's best interest, which no matter which statute you apply, the ultimate decision is based upon the best interest of the child.
Ultimate standard.
And that is what the commissioner ruled, that it's the best interest of the child would not.
How
be
much
decision.
increase does this letter offer you on what the status quo is now?
It gives him an additional day each week. It's an additional day every other week, I'm sorry. And then we had asked to modify, instead of a 2-week summer visit, that each parent have 3 7-day periods. You know, on that. Which gives him more time in the summer.
Picks up a day.
Yeah, he's currently 2 separate 2 week period.
Well, then 4 7-week uninterrupted periods for each parent.
Which is the same.
Which would be the same, but just not 2 weeks. That way the child doesn't have to do it without either parent.
For 14
18 or
days.
19 days.
You want to talk to your client, see if he wants that offer? We have an adoption. So. Is this the last case on this document? Never come over here. Tell it. Tell it.
They have additional family members that they would like to come up for the adoption.
That'd be okay. If they need to spread out back there.
Because they've had sheriff's space and everything. So. Well, Mike knows where they are. He's been.
I would propose, and speak to my client, if we just split the baby on it, my client would receive 11 days out of every 20 days. We think that's fair given where we are right now. With our offer. My client's tired of finding this out. He wants the most time he can have with his daughter, but if this is what gets him more time currently for him to continue to prove that they.
Okay, what would 11, you got 10 days there? How would you modify it to give him one more day? A month? Okay. Let's go off the record.
Adoption's a little out of order. We have a termination. But she said it wouldn't take long.
So far, I've got 147
It's the best timing because you're up there arguing and the email pops. I was like, can I ask you for a favor? The best part was like, hi, how are you doing? I was like, I just talked to you.
I have the most boring life, because I know that anything does happen.
One COVID capital.
Write you down.
We were supposed to play Monday in Aquarium. And they canceled the JV game because there were so many JV players in Aquarium that were quarantined, but they still have varsity. And our coach wanted all these go. He's like, she can't play. Just don't watch. I'm like, no.
Where'd you go?
So we're exposed to it. I asked her, she said that he had said on his class that also that he thought it could be self-employed or racing ball. It's not systematic, but.
How close do you get somewhere? Not just for a second. What it didn't know. So what? Right? But I went downstairs, I was a cook boy.
He has never worn a mask since we instituted masks.
Well, saw me mopping everything. You know, I got one of the works off. You know, when I came back around the corner, he had a big red day. It's not working.
He was saying to wear around his neck. I've never seen him with a mask on. Since he was I mean, it's up to you guys. We have to do it in the office.